Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. Today is lecture 3 of Indian Polity. Yesterday, we initiated a discussion on preamble. When we look at the text of the preamble, we can break it down into 4 areas. Number 1, we the people, which means that the source of authority of the Constitution, from which our Constitution derives its authority, are the people of India. Then, what is the nature of the Indian state? Sovereign, socialist, secular, democratic, republic. And we have explained all these phrases. And at the same time, the third thing that preamble tells us, what are the objectives of the Constitution? Objectives in the sense, liberty, equality, fraternity, dignity of an individual, justice. But justice in social sphere, in economic sphere, in political sphere. And the fourth thing that preamble tells us is the date of adoption, the date on which the Constitution of India was adopted, which is different from the date on which the Constitution was enacted. The date of adoption, 26th November 1949, is celebrated as the Constitution Day, and 26th January 1950, when the Constitution was enacted, when the Constitution entered into force, that date is celebrated every year as the Republic Day. Then we discussed, is preamble part of the Constitution? In Berubari Union case, the Supreme Court had said that it is not part of the Constitution. But then few years later, in 1973, to be precise, on 24th of April 1973, in a landmark verdict, Keshavananda Bharti versus State of Kerala, the Supreme Court said preamble is part of the Constitution. Now let's look at some of the quick points regarding preamble, and then we will jump to part 1 of the Constitution, which is Union and its territory. Number 1, US Constitution was the first one to begin with the preamble. US Constitution also opens up with "We the people of the United States of America." In a similar fashion, our Constitution, our preamble also starts with "We the people of India." Number 1. Number 2, is preamble subject to amendment to the Constitution? Now listen to me carefully. When we look at the text of the Constitution, it says in preamble, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic." And if you notice, all these important terms, democratic, socialist, secular, republic, sovereign, these are in capital letters. Have you noticed this? Not just in capital letters, there is no comma separating sovereign from socialist, socialist from secular, which means when we look at this phrase, we have to look at it together. We can't say sovereign and socialist and secular and democratic and republic, which would give us a sense that sovereign is separate, socialist is separate, republic is separate. The Constitution makers deliberately ensured that we look at this entire thing in one phrase, as one statement, which means one cannot be isolated from the other. The entire nature of the Indian state is, it is sovereign, socialist, secular, democratic republic. That means put together. We can't have sovereign and at the same time can't have republic. We can't have only democratic, but at the same time can't be sovereign. Which means this phrase has to be looked at together in conjunction with each other. We don't have to look at them in isolation. Now, the question was, can preamble be subject to the amendment to the Constitution? For that, let's understand very briefly what was this Keshavananda Bharti case of 1973. We will understand this judgment in great detail when we will discuss amendment to the Constitution. But very briefly here, the principal question before the court, 13 judges of the Supreme Court in 1973 had to decide one key question. Is the power of Parliament supreme that it can amend any provision of the Constitution? When we look at the Constitution of India, nowhere was there a limitation on the powers of the Parliament. It was not mentioned anywhere that Parliament can amend these provisions of the Constitution, but not these provisions of the Constitution. There was no such restriction, no such limitation whatsoever. But does that mean Parliament can, through amendment to the Constitution, by using Article 368, because yesterday I told you it is Article 368, this provision of the Constitution, which is used to amend the Constitution. So a bill should be passed by the Parliament under Article 368 of the Constitution to amend provisions of the Constitution. Now, the principal question before the 13 judges of the Supreme Court was, is the power of the Parliament supreme that it can use Article 368 to make any changes to the Constitution? Maybe delete fundamental rights altogether. Maybe convert our parliamentary democracy into a presidential democracy. Maybe convert our republic into a monarchy. Is the power of Parliament supreme that it can make any changes to the Constitution? Supreme Court said no. Yes, Parliament can use Article 368 to make changes to the Constitution, to amend various provisions of the Constitution, except those features which are part of the basic structure. And what is this basic structure? Let me give you a simple analogy. For example, this is a building. Can we change the color of this building? Yes. Can we change this air conditioner? Yes. Can we change the stylus? Yes. Can we change the smart panel? Yes. Can we change the teacher? Yes. But can we change the foundation of this building? We can. But then it will not remain the same building. This building will collapse. Then you have to establish another building, set up another building. That foundation, there are some features of the Constitution which are so important, so basic, so fundamental, that if Parliament changes those features, then our Constitution will not remain the same. There are some fundamental features of the Constitution. There are some basic structures of the Constitution which you cannot alter, which Parliament does not have the power to use Article 368 to change, modify, amend. Those features are what we call basic structure. For example, parliamentary democracy is part of the basic structure. No amendment of the Constitution can convert our parliamentary democracy into a presidential democracy. Republic, sovereign, socialist, secular, democratic, objectives mentioned in the Constitution, objectives mentioned in the preamble, such as liberty, equality, justice, fraternity, those are also part of the basic structure. That means Parliament cannot use Article 368 to make changes to this basic structure. And the nature of our state mentioned in the preamble is part of the basic structure. The objectives mentioned in the preamble is part of the basic structure, which Parliament cannot amend, cannot modify, cannot change, cannot alter. But then, sir, what happened through 42nd Constitutional Amendment Act 1976? When words such as secular, when words such as socialist, when words such as integrity of were mentioned, added, amended to the preamble. Now listen to me carefully. Can we delete sovereign from the preamble? No. Can we delete socialists from the preamble? No. Can we delete secular democratic republic from the preamble? No. But can we enhance the preamble? Enhance the preamble in the sense, add more objectives to the preamble? Yes. Add more features to the preamble? Yes. Add more nature to the preamble? Yes. If these changes do not affect the existing preamble, which means if our preamble says we are a secular country, you cannot add Islamic State or a Hindu Rashtra. Because if the preamble says, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, Hindu Rashtra or Islamic State is incompatible with the idea of a secular state. So you cannot add Hindu Rashtra, you cannot add Islamic State to the preamble. But can we ensure that we add gender justice to the preamble as one of the objectives of the Constitution? Yes, we can. That means we can make any changes to the preamble so long as it does not destroy the basic structure. By adding the word secular, the basic structure was not destroyed. By adding the word socialist, by adding the word integrity, the basic structure was not destroyed. In fact, the Supreme Court has said secularism is also part of the basic structure of the Constitution, which no amendment to the Constitution can change. Long story short, what are these quick points that you have to remember? One, US Constitution was the first one to begin with the preamble. Number one. Number two, can preamble be amended? We can say preamble can be enhanced or enriched. Because if we use the term amendment to the preamble, it can also allude to a fact that we can delete sovereign, socialist, secular, democratic, republic, liberty, justice, equality, fraternity, dignity. We can't do that because all this is part of the basic structure of the Constitution. Without disturbing them, can we add more nature to the Indian state? Yes. Can we add more objectives to the Constitution, to the preamble? Yes. That means the objectives mentioned in the preamble, the nature of the Indian state mentioned in the preamble is part of the basic structure of the Constitution, which no amendment of the Constitution under Article 368 can violate. Is that clear? Then what is the significance of preamble? We say preamble is not enforceable in a court of law. Now, what do we mean by legal enforceability? For example, next week onwards, we will start discussion on fundamental rights. So, right to equality is a fundamental right. Freedom of speech and expression is a fundamental right. Liberty, justice, all these are important features of our Constitution. If your fundamental right is violated, what is the option available with you? The option is you knock the doors of the Supreme Court. Supreme Court will protect your fundamental rights. The Supreme Court will restore your fundamental rights, which means fundamental rights are enforceable in a court of law. At any point in time, if the government is violating your fundamental rights, if the parliament is violating your fundamental rights, you can drag the government to the court. That means fundamental rights are enforceable in a court of law. Preamble is not. Because what is preamble? Preamble is the philosophy of the Constitution. Preamble is the identity card of the Constitution. Preamble is like the preface to the Constitution. Preamble itself is not enforceable in a court of law, which means you cannot approach the Supreme Court and ask the Supreme Court to implement preamble. Direct the government to not violate the preamble. Preamble is not enforceable in a court of law. But then what is the significance? Even if preamble is not enforceable in a court of law, but what is mentioned in the preamble? Justice, social, economic, political. To implement this objective of the Constitution, we have fundamental rights. Liberty of thought, belief, freedom of expression, although it is one of the objectives of the Constitution mentioned in the preamble, but preamble is not enforceable in a court of law. Doesn't matter. To implement preamble, we have fundamental rights. If these fundamental rights are violated, you can knock the doors of the Supreme Court. Supreme Court will protect, guard your fundamental rights. But sir, then what is the significance of preamble? We say preamble aids the legal interpretation of the Constitution where the language is found to be ambiguous, where the language is found to be not clear. And for that, let's look at an example. Aadhaar, a unique 12-digit identification number. Every resident of India is eligible for Aadhaar. Every resident, not every citizen. Who can be a resident of India? Citizen of India, foreigner as well. Who is this resident? Any person who is staying in India for 6 months or who intends to stay in India for 6 months, that individual becomes a resident. That means resident can be either a citizen or a foreigner. This resident is eligible for Aadhaar because Aadhaar is not a proof of citizenship. Aadhaar is the proof of identity. Aadhaar only proves Sarmad is Sarmad. Aadhaar does not say that because you have Aadhaar, Mr. Sarmad, you are the citizen of India. Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. But then, how do you enroll for Aadhaar? You have to give your biometric data. For example, your fingerprint scan, your iris scan. The question argued was that Aadhaar violates privacy. What sort of privacy? If I give my fingerprints, if I give my iris scan, I'm parting away with some of my intimate details, which basically violates my privacy. And as such, the question was, Aadhaar is unconstitutional. Because Aadhaar asks the individuals of India to part away with their biometric details. As such, it is unconstitutional because it violates right to privacy. Matter went to the court. Former judge of Karnataka High Court, Mr. K.S. Puttaswamy, he approached the Supreme Court and argued that Aadhaar is unconstitutional because it violates right to privacy, which is a fundamental right. The Supreme Court asked the government, what is your take on this matter? Here is a petitioner who has approached us saying Aadhaar scheme violates my fundamental right to privacy. Government said there is no such fundamental right as right to privacy. The Supreme Court asked, what are you saying? The government said, we repeat, there is no such thing as a right to privacy as a fundamental right. Said, how can you say this? Show me all the articles mentioned under fundamental rights chapter and tell me if one article explicitly talks about right to privacy being a fundamental right. The government was right. There is no mention of right to privacy as a fundamental right in the Constitution. No fundamental right talks about explicitly right to privacy. That means the language is ambiguous. The language is not clear. How? Article 21 talks about right to life and personal liberty. The state shall not deprive an individual of his right to life and personal liberty. Mr. Puttaswamy argued that life becomes meaningless unless and until you have privacy. Nobody should have the right to enter the private room of my house. Nobody should have the right to decide what I should wear, not wear, what I should eat, not eat, drink, who I should make love to, who I should sleep with. That is not the power of the state. State cannot interfere. This life becomes meaningless unless and until we have privacy, unless and until the state is not allowed to interfere. The Supreme Court said, look at the objectives mentioned in the preamble. Objectives are justice, liberty, equality, fraternity. One such objective is dignity of an individual. The Supreme Court said, we will look at the preamble. In the preamble, it is mentioned as one of the objectives of the Constitution as dignity. Dignity of an individual is not possible unless and until we give them privacy. So right to privacy is a fundamental right under Article 21 of the Constitution, ruled the Supreme Court. Which means Supreme Court expanded the scope of Article 21. Because Article 21 talked about right to life and liberty. The Supreme Court said this right to life and liberty also includes right to privacy, which is a fundamental right. Because if one of the objectives of the Constitution mentioned in the preamble is dignity, dignity is impossible without providing individuals their right to privacy. So what is then the significance of preamble? It aids, it helps in the interpretation when the language is found to be ambiguous. That's the significance of preamble. So preamble can be amended, yes, but without altering the basic structure of the Constitution. So without altering the existing nature of the Indian state, which is sovereign, socialist, secular, democratic republic, you can add more nature, but you cannot delete anything. At the same time, objectives mentioned in the Constitution, preamble, can be further enhanced, further enriched. More objectives can be added without deleting the existing objectives. So preamble can be amended, but subject to the basic structure of the Constitution. But preamble is not enforceable in a court of law. That means, unlike fundamental rights, if they are violated, if the fundamental rights are violated, you can approach the court will protect your fundamental rights. But you cannot approach the court if you think preamble has been violated, because preamble is not enforceable in a court of law. But then what is the significance of preamble? If it's a beautiful document, if it's the philosophy of the Constitution, but it is not enforceable in a court of law, don't worry. Why? Because the objectives mentioned in the preamble are enforced through fundamental rights. If the objective of the Constitution mentioned in the preamble is liberty, that is implemented through fundamental rights chapter. If the objective of the Constitution is justice, that is implemented through other provisions of the Constitution. If the objectives mentioned in the preamble are dignity of an individual, that is ensured through other provisions of the Constitution. And the significance of preamble is it helps in the legal interpretation of the Constitution if the language is found to be ambiguous. Two more things. One, if any power is not given in the Constitution, preamble can't provide. And if any power is not stopped in the Constitution, Parliament can't stop. What does that mean? Let's say, for example, we have Article 13 of the Constitution, which we will discuss in Fundamental Rights chapter, but very briefly here. Specifically, Article 13, Clause 2. What does Article 13, Clause 2 say? That state cannot pass any law through which it can delete a fundamental right. State cannot pass any law through which it can delete, modify, abridge a fundamental right. That means some power is not given in the Constitution. What is that power? Power is not given to the Parliament to delete a fundamental right. If this power is not given by the Constitution, preamble also cannot provide. In a sense, can tomorrow the government say that we can delete all these fundamental rights? The court will ask how? This is not the power given to you in the Constitution. The government can say, but look at the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign. Sovereign means we can make any decision, we can unmake any decision. That means preamble tells the Indian state that you are sovereign. And if you are sovereign, you can take any decision. You can make any decision. You can unmake any decision. But if the power to delete fundamental right is not given to you, We can't say preamble provides you that power. Preamble can't provide a power which the Constitution has not given. Similarly, if a power is not stopped in the Constitution, preamble can't stop. Can we say that the Constitution of India can be amended by Article 368? Yes. And by using Article 368, can Parliament amend basic structure of the Constitution? No. Which means if any power is not stopped in the Constitution does not allow Parliament to alter the basic structure of the Constitution, we can't say preamble will help the government and say you can amend any provision of the Constitution. There is no such thing as basic structure. Long story short, what is this beautiful text called the preamble? Preamble is the philosophy of the Constitution, identity card of the Constitution. It's like the preface to the Constitution. This preamble can be broken down into 4 areas. We've discussed that. But then what is the significance of preamble? 1, preamble aids in the legal interpretation where the language is found to be ambiguous, where the language is found to be unclear. For example, we were not sure whether right to privacy is a fundamental right or not, because explicitly it was not mentioned in the Constitution. But Supreme Court interpreted using preamble, because in preamble, one of the objective mentioned is the dignity of an individual. The Supreme Court, which is the final interpreter of the Constitution, the final authority to interpret the Constitution is the Supreme Court of India. And Supreme Court says dignity cannot be ensured unless and until people have privacy. So right to privacy is your fundamental right. But preamble itself is not enforceable in a court of law, which means you can't approach the court saying preamble has been violated or preamble has not been implemented, because it is just the philosophy, it cannot be implemented. But at the same time, if there is a power given, let's say, to the judiciary by the Constitution, that judiciary can impart justice, you cannot go to the court and say, we will give this power to executive to impart justice by invoking the principle of sovereignty mentioned in the preamble. So if there is a power given in the Constitution, Supreme Court can't stop, preamble can't stop that power. If a power is not given in the Constitution, preamble cannot provide that power, because preamble is not enforceable in a court of law. That completes our discussion on preamble. If you have any questions, let me know. Then we will jump to part 1 of the Constitution. Then what about right to property? How can it be deleted despite it was a fundamental right? We will discuss that in directive principles of state policy. For that, we have to understand a lot. We have to understand Golaknath judgment, Keshavananda Bharati judgment. We will discuss it there. Sir, what is the final take of government in Aadhaar case? Aadhaar is constitutional. Right to privacy is also a fundamental right. Because we will discuss in fundamental rights, these fundamental rights are not absolute. Absolute in the sense, if I have freedom of speech and expression as a fundamental right, that means I can say whatever I have to say, express whatever I have to express. That doesn't mean I can say something which goes against the sovereignty and integrity of India, which goes against public order. I cannot give a hate speech. I'll just give you a simple analogy. You're watching the movie Pathan, if you haven't watched it yet. Or I'm not asking you to watch that movie. But be that as it may, for example, you're watching that movie in a theater, Pathan, but suddenly you get up, fire, fire, fire. The Pathan movie is running houseful. Tickets are not available. Everybody seems to be watching Pathan. There are 200 individuals watching Pathan in a theater, and suddenly you say, fire, fire, fire. Now what will happen? Stampede. everybody will start going here and there to save himself or herself. At the end of the day, when there is a stampede, when you are saying fire, 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 and then there are people who are trying to move towards the exit gate, hundreds of them, there is a stampede. Some of them may also die, unfortunately. But you're sitting on your chair, eating popcorn, and the police comes and says, "What have you done? Why did you cry fire, fire, fire where there was none?" You can't say, "I have the freedom of speech and expression. I can say whatever I have to say. I can express whatever I have to express. I just realized I should cry fire, fire, fire. So that's my freedom of speech and expression." But your freedom of speech and expression can be restricted on the grounds of public order. By crying fire, 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 you have violated the public order because there was a stampede. So fundamental rights basically are not absolute. Restrictions can be imposed on your fundamental rights. Similarly, if right to privacy is a fundamental right, that doesn't mean right to privacy cannot be violated or restrictions imposed on right to privacy. The Supreme Court has said this right to privacy can be restricted on the grounds of legitimate state interest. The government was asked, what is the need for Aadhaar? The government said there is duplication, there is leakage in our existing system. The court asked, what is that leakage? What is that duplication? Sir, we used to provide various benefits, welfare schemes to the poor, marginalized sections of the society. If we were paying them 1 rupee, only 15 paisa would reach them. 85 paisa would be pocketed by the middleman. So if there is an old woman and the state is providing 600 rupees of old age pension every month, initially what we used to do, we used to ask somebody, a government officer for example, that this is 600 rupees, give it to that old woman. He would pocket 500 himself and give only 100 rupee to that old woman. So there was a leakage. Others would do something else as well. Others would say there are 10,000 old women who are eligible for old age pension, while in reality, there are only 100. That means there is duplication. Those who are not eligible, suddenly ghost names are created. Suddenly your own names are added as beneficiary. Now what we will ensure, every single beneficiary should have an Aadhaar, which is unique. Unique because fingerprints are unique, iris scan is unique. A unique 12-digit identification number will be given to everybody. This Aadhaar will be linked to your bank account. That means bank account will be one, linked to your Aadhaar. That means we know who the beneficiary is. And this 600 rupees of pension will directly be deposited into the bank account of this old woman without any interference by a middleman. That is why we need Aadhaar, to ensure there is no leakage, to ensure there is no duplication. That means although Aadhaar asks you for your biometric details, fingerprint, iris scan, which you may say violate your privacy, but right to privacy, although it is a fundamental right, but it is not an absolute fundamental right. Restrictions can be imposed. That means you can be asked to give your fingerprint because there is a legitimate state interest. And it is the legitimate state interest to prevent leakage, to prevent duplication of the system. That's why Aadhaar is constitutional, and at the same time, right to privacy is also a fundamental right. Preamble is not justiciable, which means it is not enforceable in a court of law. Is anywhere mentioned in Constitution that basic structure cannot be amended? There is no such thing as basic structure mentioned in the Constitution. This is the interpretation of the court. The Supreme Court has said that there is something called basic structure. Because who is the final interpreter of the Constitution? Supreme Court. We can say Constitution is what Supreme Court says it to be. Okay. Now let's look at Union and its territory, part 1 of the Constitution. Here we have to discuss Articles 1 to 4. But listen to me carefully. Sir, do I have to memorize all the articles of the Constitution? No. Sir, do I have to memorize what is Article 1, 2, 3, 4? No. Just understand the concept. But I will still go by article so that there is continuity, so that there is flow. Yes, there are some articles which you must remember, you must memorize. Because once you use those articles in your answers, you will get better marks, good marks. And which are these articles? I will tell you one by one which are these articles which you should memorize, which you should remember. Mostly those articles which are in the news. For example, 19(1)(a), Article 21, Article 32, Article 142, Article 356, Article 360. These are the important articles which you must remember, which you must memorize. But you don't have to memorize the entire Constitution's article one by one. Don't do that, just understand the concept. And which are the articles which you must remember, which you must memorize? I'll tell you one by one. And the first article that you should memorize, remember, is Article 1. As of now, we have 28 states and we have 8 union territories. What is a state? What is a union territory? How a state is different from a union territory? We will discuss that separately in a chapter known as Union Territory. Here we are not talking about union territory. We are talking about union and its territory. Because once the Constitution is framed, first we have the preamble, which is the philosophy of the Constitution. Then this Constitution is for the entire country. What should be the geographical spread of this country? What should be the area of this country? For that, we should have the first understanding. That is why the first thing, the first part of the Constitution talks about union and its territory. What is the territorial strength of India? That is mentioned in part 1. Now let's look at part 1 of the Constitution one by one. First up, Article 1, Clause 1 of the Constitution. Don't remember these clauses, don't memorize these clauses, just understand the concept. But Article 1, this one, you should remember. What is Article 1, Clause 1? India, that is Bharat, shall be a union of states. There are two things involved here. First, why are there two names for India? India as well as Bharat. And what do we mean by this phrase, union of states? Let's have an understanding. When the Constituent Assembly, which was responsible for drafting the Constitution, when it met, there were debates on all things. Should our country be secular or should it be a theocratic state? Should we have a parliamentary democracy or a presidential democracy? Everything should be debated. That's how we can come up with our Constitution, with a beautiful document. Should there be governor or not? What should be the role and responsibility of the judiciary? What should be the emergency provisions of the Constitution? Everything was debated. There was a debate also on the nomenclature. What should be the name of this country? Some members of the Constituent Assembly said, let's stick with India, because that's how we are known throughout the world. We should call this country India. Others said, no, India is the name given to us by foreigners. Why should we call this country India? We have now come out of colonialism. We have now come out of imperialism. We are now an independent country. We should go back to our previous name, which is Bharat. Others said, why Bharat? Why India? Why not Hindustan? Others said, no, why Hindustan? Why India? Why Bharat? Why not call it Jambudvip, the land of the Jambu tree? That's how previously we were known once upon a time. There were some members in the Constituent Assembly who were very inspired by USSR, which is today's Russia. USSR, Union of Soviet Socialist Republic. They were inspired by USSR and they said we should have a similar name. Union of Socialist States of India, Union of Socialist States come Republic of India. That means there was a lot of debate, discussion on what should be the name, what should be the nomenclature of this new country, what should we call this country. And ultimately there was a consensus. The consensus was, let's have a dual name. Let's call this country India as well as Bharat. India reflecting modernity, the modern name by which we were known, and tradition, Bharat. So India, that is Bharat, should be the name of this country. We have dual name. At that time, everybody was satisfied. Those who believed in modernity, they said, look, the name of this country is India. Why? Because it starts with India. Traditionalists said, no, the real name of this country is Bharat. Why? Because it says India, that is Bharat. So Bharat is the real name of this country. But ultimately, the dust settled. We have two names for this country, dual name, India, that is Bharat. But even then, there were petitions filed in the court. A petition was filed in the court a few years ago saying, dear Supreme Court, please issue a directive to the government that we should call this country only as Bharat and not India. So issue a directive and say the real name of this country is Bharat, not India. The Supreme Court dismissed this petition, saying, don't come to us with these frivolous petitions. Use your power to solve corruption in the society, to solve the problems of lack of nutrition amongst the children, to solve the problem of women atrocities. Don't come to us with these frivolous petitions, useless petitions, whether the name of this country is India or Bharat. You want to call it India? Call it. You want to call it Bharat? Call it. Because the Constitution has given us two names, dual name. India, that is Bharat. So Article 1, Clause 1 of the Constitution says, India, that is Bharat. What do we mean by that? We have two names for this country, reflecting modernity, reflecting tradition. It's a beautiful, convenient marriage of tradition and modernity. India, that is Bharat. But India, that is Bharat, shall be a union of states. This is where there was a heated debate in the Constituent Assembly. Dr. B.R. Ambedkar was the architect of the Constitution. He was asked, why have you used the phrase union of states? Does that mean our Constitution is unitary? Because if our Constitution is federal, then Article 1, Clause 1 should have mentioned, India, that is Bharat, shall be a federation of states. Why have you used the phrase, India, that is Bharat, shall be a union of states? Are you making it explicit that our Constitution is unitary, it is not federal? Dr. Ambedkar in his reply said, Indian Constitution is federal. We are a federal polity. Our Constitution is federal. But I have used the phrase union of states for two reasons. The members asked, what are these two reasons, Dr. Ambedkar? He said, number one, India is not the result of an agreement between states, and number two, no state has the right to secede from the Union of India. It's for these two reasons that I've used the term Union of States. Ours is a federal constitution, but I have not used the term India, that is Bharat, shall be a federation of states. I have used the term India, that is Bharat, shall be a union of states because of two reasons. Reason number one, India is not the result of an agreement between states. And number two, no state has the right to secede from the Union of India. Members of the Constituent Assembly said, please elaborate. We don't understand your technical knowledge, because tomorrow civil services aspirants have to prepare this topic. I said, okay, I'll explain. In North America, there were 13 British colonies. Britain was the biggest colonizer of its times. It was under the British rule that there was a vast majority of Asia, Africa, as well as North America. So in North America, there were 13 British colonies. Just like India was a colony of Britain, in the similar fashion, there were 13 British colonies in North America. Now, these 13 British colonies revolted. They wanted independence. And that is what we call American War of Independence, which you will study in great detail in world history. But these 13 colonies of the British revolted against the British Empire, revolted against the Queen for seeking independence, and they became independent. So now these 13 colonies of the British, when they declared war, America's War of Independence, they liberated themselves. Now these are 13 independent states, 13 independent countries. These 13 independent countries decided to come together. They met at Philadelphia in United States of America. They decided to come together. They decided to have an agreement so that all these 13 independent states will be known as United States of America. That means these were 13 colonies. Now they revolted. They became independent. Now they wanted to have an agreement so that all these colonies can be united. All these independent states can be united. And that agreement led to United States of America. But then they said, how do we govern all these territories? Should there be a central authority? What should be the role of these individual states? What sort of democracy should we have, presidential or parliamentary? That is how in 1787 they created a document known as the US Constitution, which is considered to be the oldest federal constitution of the world, where some powers were given to the center, some powers were given to the states as well. Distribution of powers. But United States of America as a political entity was not present. It was created when these 13 independent states decided to come together to have an agreement, sign an agreement, and create a political entity known as United States of America. India was not created like that. India was already there. But Dr. Ambedkar, what about these princely states? More than 562 princely states, which were previously governed by the princes, which were under monarchy. They have also decided to come together and join India. Dr. Ambedkar said yes. But these princely states, they did not sign an agreement to create India. India was already there. They decided to merge with India. So India as a political entity, it was not created like United States of America. India as a political entity was already present. Other princely states decided to join India. Princely states did not create an agreement to create India. India was already there. They decided to merge with India. That is why I have used the term Union of States. Because if I would have used the term India, that is Bharat, shall be a federation of states, the implication would have been, a misleading sense would have been that India is just like United States, which was created when states decided to enter into an agreement. And once you have entered into an agreement, at any point in time, you can come out of that agreement as well. Few years ago, I entered into this agreement. Now I don't think it is working for me. I come out of it. So in a federal polity, basically, when there is an agreement, when there is a federation of states, when there is a federal polity, when the states have decided to come together through an agreement to create a political entity, at any point in time, one state may come out of that federation because it was through an agreement that we created an entity. Now I want to come back. If I have used the term Union of States, that means no state has the right to come out of the Union of India. If I would have used the term Federation of States, that means at any point in time, a state could have said, I want to come out of this federation, which we cannot allow. So part 1 of the Constitution, where we have to discuss Articles 1 to 4, We're discussing Article 1. More specifically, we are discussing Article 1, Clause 1. India, that is Bharat, shall be a union of states. Two things we have to understand here. India, that is Bharat, which means we have a dual name. There are two names for this country, reflecting tradition and modernity. Clear? India, that is Bharat, shall be a union of states. Does that mean our constitution explicitly says that Indian constitution is unitary? Because it says union of states, which means unitary constitution. If it was a federal constitution, then the term would have been India, that is Bharat, shall be a federation of states. Dr. Ambedkar, please elaborate. Dr. Ambedkar said ours is a federal constitution. But I've used the term union of states for two reasons. Number one, India, unlike the United States of America, is not the result of an agreement between states. India was already there. Other states decided to merge with India. And no state has the right to come out of the Union of India. That is why India, that is Bharat, shall be a union of states. Any questions as of now? No. Okay. Very nice. Article 1, Clause 2. The states and territories thereof shall be specified in the first schedule of the Constitution. Now, what is a schedule? Schedule is an explanatory memorandum of an article. What do we mean by that? Article 1, Clause 2 says the names of the states and territories thereof. We have 28 states. We have 8 union territories. Where would their names be specified? These names will be specified in first schedule of the Constitution. But what is a schedule? Schedule is basically an explanatory memorandum of an article. If an article requires more explanation, we don't add the explanation in the article itself. We add this explanation at the end of the Constitution by creating a schedule. But sir, why? This is for cosmetic reason. Cosmetic reason in the sense, maybe the members of the Constituent Assembly at that time realized lean is in. If you're leaner, you will look good. If you're bulky, you will not look good. I'm not fat shaming. I'm just making a point clear. The point is, if the names of the states and territories thereof are mentioned below, that means this article would be very bulky. Because this article would have the names of 28 states and 8 union territories. That means if this explanation to Article 1 would not have been mentioned in the schedule of the Constitution, then Article 1, Clause 2 would have looked very bulky. India, that is Bharat, shall be a union of states. The names of the states and territories thereof are mentioned below. Below we will have 28 states and 8 union territories. This article would look very bulky. That's why whatever explanation is required. What is the explanation? Which are these 28 states? Which are these territories? Their details will be mentioned in a schedule of the Constitution. So what is a schedule? It's an explanatory memorandum of an article. If an article requires more explanation, add that explanation at the end of the Constitution in the form of a schedule. This is just so that the articles don't look bulky. And this is Schedule 1 of the Constitution. Jammu and Kashmir, for example, what is the territory of Jammu and Kashmir? Mentioned in Schedule 1. Explanation is provided. This is Nagaland. What is the territorial spread of Nagaland? Explanation is provided. Similarly, Haryana, Himachal Pradesh, Manipur. Long story short, the details of all the 28 states and 8 union territories are mentioned where? In the first schedule of the Constitution. How many schedules do we have? We have 12. And all these schedules we will discuss one by one. Clear? But here we encountered Schedule 1. We will explain Schedule 1. So Article 1, Clause 1. India, that is Bharat, shall be a union of states. Is that clear? No confusion here? Very good. The names of the states and the territories thereof shall be specified in first schedule of the Constitution. We know what is the first schedule, the details of 28 states and 8 union territories. Article 1, Clause 3. The territory of India shall comprise up of. If India is a territory, if India is a nation, what is the territorial spread of India? Either we can have the territories of the states, that means we can have states in India, or we can have union territories, or we can have acquired territories. If this clause C was not mentioned, then our territory would have remained fixed forever. Either we can have states or we can have union territories. So all the states that we have right now, all the union territories that we have right now, this is the territory of India, that's it. But tomorrow we want to acquire Pakistan, then we want to acquire Bangladesh, then we want to acquire Afghanistan, and very soon we will acquire China as well, then Myanmar, then all other countries. So territorial strength can be increased as much as possible. If at all we acquire foreign territories, those territories will also be part of the territory of India. So the territory of India, we can have either states of India or union territories or some of the territories which may be acquired. Sir, have we acquired any territory? Yes, we have. One beautiful example of that is the French settlement or French colony of Puducherry, which was previously known as Pondicherry. Then the name was changed to Puducherry. Pondicherry or Puducherry, it was basically part of France. 1947, we got the independence. And in 1954, there was an agreement between the government of India and the government of France that let's cede this territory, let's give this territory to India. And ultimately, Puducherry became an acquired territory of India. We acquired Puducherry from France. But from 1954 till 1962, we were governing Puducherry as an acquired territory because the territory which has been acquired. Because you can't simply acquire a territory by just having an agreement between the government and the government. Sir, what does that mean? Government of India and the government of France, they had an agreement that Puducherry or Pondicherry will be given to India. But this decision which was taken by the government of France should have been ratified, should have been supported by the Parliament of France. Because it can't be an individual decision of the government of a country. Their legislature, their parliament has to be involved so that their legislature empowers this secession, empowers this acquisition. And ultimately, it took some time. And finally, the French Parliament in 1962 said, okay, we agree with this acquisition by India of our territory called Puducherry. That means till the time it happened, till the time the Parliament of France gave its imprint on this acquisition, till 1962, Pondicherry was administered as an acquired territory. Once the acquisition was final in 1962, Pondicherry was converted into a union territory. And even till date, Pondicherry or Puducherry is a union territory, which means Article 1, Clause 3 says, the territory of India, what you call India, we can have either states or we can have union territories or we can have acquired territories, territories that may be acquired by the government of India. That completes Article 1. Any questions as of now? What about people of that territory? Do they all become the citizen of India? The government of India will specify who are these people of Pondicherry who will become citizens of India. So automatically all people of Pondicherry will not become citizens of India. The government will specify who of these citizens, who of these individuals can become the citizens of India. Okay, let's look at Article 2 of the Constitution. Article 2 says Parliament may, by law. What Parliament can do? It can pass a law. Through this law, what it can do? It can admit into union or establish new territories on such terms and conditions as it thinks fit. So what is Article 2? Parliament may, by law, admit into or establish new states on such terms and conditions as it thinks fit. And the beautiful example of Article 2 is the Indian state of Sikkim. Let's understand it briefly. Sikkim was a monarchy. It was ruled by an institution. That institution was known as Chogyal. Chogyal is like Guptas, Mauryas, Mughals. Rulers can be different. Akbar, Jahangir, Aurangzeb. But the institution is the Mughals. Similarly, rulers were different, but the institution of monarchy in Sikkim was Chogyal. 1947, when India gained independence, Sikkim, under this institution of monarchy known as Chogyal, decided to have an agreement with India. Under this agreement, Sikkim became the protectorate of India. What is this protectorate? Here is a stronger country. This stronger country protects a weaker country. How? Through diplomacy, through military strength. For example, in 1947, Chogyal and the government of India entered into an agreement under which Sikkim, which is a weaker country, became the protectorate of a stronger country known as India. So India said, we will protect you. If China comes to you, violates your sovereignty, attacks you, we will defend you militarily. If somebody is attacking you at the United Nations, we will protect you there diplomatically. So India, a stronger country, becomes the protector of a weaker country, Sikkim. So Sikkim became the protectorate of India. But slowly and steadily, the people of Sikkim, they were fed up of Chogyal. And at the same time, they wanted to be very close to India. And then what happened in 1973, there was a spring, a movement launched by the people of Sikkim where they revolted against the Chogyal. There were a series of protests, series of demonstrations, and it is argued, I don't know whether that's correct or not, but it's a good thing if it has indeed happened. Some analysts say that RAW played an important role in fueling these protests. RAW, which is the External Intelligence Agency of the Government of India, Research and Analysis Wing. So there were a series of protests, demonstrations in Sikkim. Basically, people of Sikkim wanted democracy. They wanted an end to this institution of monarchy. And at the same time, they wanted to be closer to India. Protests continued. Ultimately, India entered into the picture and started negotiation. Now, there were three parties to this negotiation: India, the protesters, and the institution of monarchy, Chogyal. India persuaded Chogyal that you should do elections, you should organize elections in Sikkim. Organize elections so that people can have sense of democracy. The Chogyal relented, and ultimately there were elections in Sikkim. And once the elections were conducted, the results were declared. A pro-India political party known as Sikkimese Congress, they won the election. And when this pro-India Sikkimese Congress won the election, they got the majority in the Sikkimese parliament. They passed a law. and they passed a law known as Government of Sikkim Act 1974, under which they turned this Chogyal, who had all the power, this Chogyal was turned into a nominal constitutional head, just like the Queen of England. In a sense, that real power will be with the Sikkimese parliament. The real power will be with the elected representatives of the people of Sikkim. Chogyal is now a ceremonial head. He's like the Queen of England without any powers. He's just a ceremonial figure, that's it. Chogyal, he went around different parts of the world and he alleged that India is doing all of this. Please help me, please save my monarchy. And ultimately, a constitutional amendment was passed by the Indian Parliament. The year was 1974. Under this 35th Constitutional Amendment Act, Sikkim was made an associate state of India. Associate state of India. And this is where the opposition attacked the then Prime Minister, Shrimati Indira Gandhi. You have violated the Constitution. You have destroyed the Constitution. You are a dictator. She said, why? She asked why. Look at Article 1, Clause 3 of the Constitution. The territory of India shall consist of either we can have states, or we can have union territories, or we can have acquired territories. How dare you admit Sikkim as an associate state? There is no such term as associate state in the Constitution of India. Either we can have states or union territories or acquired territories. There is no such provision of an associate state. Indira Gandhi said, have patience. When this Government of Sikkim Act was passed, Chogyal was converted into a nominal constitutional head. And then he started traveling different parts of the world, alleging that India is fueling these protests. India is violating my sovereignty. The government of India asked the parliament to amend the constitution. 35th Constitutional Amendment Act was passed. Sikkim became an associate state. Indira Gandhi was asked, how can you do this? Indira Gandhi said, look at Article 2 of the Constitution. Said, what is Article 2? Parliament may, by law. What Parliament can do? It can pass a law. Which law was passed? 35th Constitutional Amendment Act. Parliament may, by law, Constitutional Amendment Act, admit into or establish new states on such terms and conditions as it thinks fit. That means it is the discretion of the Parliament. On any terms and conditions, it can admit into India or establish new states. So we are admitting Sikkim as an associate state. And she was diplomatically right. Because if Sikkim would have been admitted as an acquired territory, then the world powers, the other countries of the world would have asked India, where is this acquisition? This acquisition has to be legal, otherwise we will not accept Sikkim as your territory, as part of India. Because acquisition has to be done by Chogyal as well. Chogyal, although a ceremonial head, although a constitutional head, but at least he should be involved. That is how Indira Gandhi played brilliant diplomacy and ultimately admitted Sikkim as an associate state. But then very next year, in 1975, there were a series of protests again in Sikkim, and now the people of Sikkim participated in a referendum. What is the referendum? Now the government of Sikkim is asking the people of Sikkim, is referring a matter to the people of Sikkim. What do you want? Do you want complete integration with India? And at the same time, we will dissolve the institution of monarchy. We will abolish the institution of monarchy. So the government of Sikkim in 1974 converted and turned Chogyal from a powerful figure, from the ruler, to a nominal constitutional head, titular head, who just has a title, but he doesn't have any powers. And now 1 year later, they're asking the people that we will abolish this institution of monarchy, completely abolish it. And please tell us, should we be completely part of India? Overwhelming majority, more than 98% people of Sikkim voted in favor of India. When it voted in favor of India, the government said in Sikkim, this institution of Chogyal is hereby abolished and Sikkim shall henceforth be a constituent unit of India enjoying a democratic and fully responsible government. Indira Gandhi said, well done. Now we will amend the constitution. Said, what is the need to amend? 36 Constitutional Amendment Act of the Constitution. What is the need? Previously, we admitted Sikkim as an associate state. Now we will delete it and we will admit Sikkim as a full-fledged Indian state. Full-fledged Indian state. Which means 35th Amendment made Sikkim an associate state of India. 36th Amendment dissolved the 35th Amendment and made Sikkim a full-fledged state of India. Which means Article 2 of the Constitution. Parliament may, by law, what Parliament can do, it can pass a law. And through this law, what it can do, it can admit into India from outside or establish new states on such terms and conditions as it thinks fit. In 1974, Sikkim was admitted as an associate state. Although Constitution had a provision that either we can have states or union territories or acquired territories. But a novelty was introduced. A new thing was introduced when Sikkim was made an associate state. But very next year, when the people of Sikkim, overwhelming majority of the people of Sikkim, in their referendum is when the government sends a matter, refers a matter to the people, asking the views of the people on that matter. The government of Sikkim referred this matter to the public, asking them, should we be full-fledged, complete part of India or not? More than 98% people of Sikkim said, yes, we should be fully part of India. And that is how then Parliament of India amended the Constitution again, removed Sikkim as an associate state, and instead made Sikkim a full-fledged Indian state. That's Article 2. Any questions as of now? Any questions, my dear? In which year Sikkim merged with India? 1975. It was the complete merger. No. Okay. Now let's look at Article 3 of the Constitution. Parliament may, by law. What Parliament can do? It can pass a law. Through this law, what Parliament can do? It can bifurcate a state. That means one state can be split into two or more. What Parliament can do? Pass a law. Two or more states can be merged to create one state. What Parliament can do? It can change the name of a state, increase the area of a state, decrease the area of a state, alter the boundaries of the state. All this is power given to the Parliament under Article 3 of the Constitution. In our first discussion, the first class, I told you a distinction between a unitary constitution and a federal constitution. Didn't I? Yes. And I told you that in normal circumstances, we are a federal constitution. In abnormal circumstances, we are a unitary constitution. Right? But at the same time, I told you that Indian constitution is biased in favor of a strong center. What is the phrase that I've used for that? Centralizing tendency of Indian federalism. Despite federalism, there are provisions in the Indian constitution which are biased in favor of the strong center. And I told you that we will keep this topic open, unitary versus federal. We will keep this topic open. We will revisit this topic And now we are revisiting this. One centralizing tendency of Indian federalism is Article 3 of the Constitution. That means this power to split a state, to merge two or more states, to change the name of a state, to increase the area of a state, to decrease the area of a state, to alter the boundaries of the state, all this is the power given to center, which is parliament. This is not the power given to the states. So Indian Constitution is biased in favor of a strong center. It creates center as a strong entity as compared to the states. This doesn't happen in United States. In United States, a state cannot be split without the state's approval. If the state of Florida wants to split itself, it can. But the central government cannot split Florida, cannot split Illinois, cannot split Michigan, cannot split Chicago. That's not the power available with the center in US Constitution. That is why we say US is indestructible union of indestructible states. States cannot be destroyed in United States without the approval by the states. India, on the other hand, is an indestructible union. Union cannot be destroyed. Indestructible union, but of destructible states. States can be bifurcated, trifurcated, split, merged, names can be changed, boundaries can be altered, area can be increased, area can be decreased. But this is the power which is given not to the states, this is the power given only to the center, which is the parliament. So what is Article 3 of the Constitution? Parliament may, by law. What Parliament can do? It can, through law, increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of a state, split the state, merge two or more states. That's the power available with the Parliament under Article 3 of the Constitution. But even then, there is a consultative process to be followed. What is the consultative process? For that, we will understand how Andhra Pradesh was reorganized in 2014. Andhra Pradesh was split in 2014, was bifurcated in 2014 into Andhra Pradesh and Telangana. Why? Because there was a demand for a separate state of Telangana. Why the demand? There was a movement led by the current Chief Minister, Mr. KCR, Telangana Rashtriya Samiti, there should be a separate state for Telangana. This movement was led by various student union leaders as well, various activists as well. Osmania University was the hub of this movement to separate Telangana from Andhra Pradesh. Why? Because they alleged that we are being discriminated in government jobs, in educational opportunities by the coastal Andhra, by the Rayalaseema region. Whether these are genuine concerns or misplaced concerns, I don't know. That's for the people of Andhra to decide. That's for the people of Telangana to decide. I'm no one to judge or prejudge them. But this was the allegation. And basis that allegation, there was a movement for a separate state of Telangana. There was a series of protests, and ultimately the then government, the UPA government, headed by Dr. Manmohan Singh, decided to, okay, yes, let's split, let's bifurcate Andhra Pradesh into Andhra and Telangana. Because if we have to split a state, who has the power to pass a law to split a state? Parliament, under Article 3 of the Constitution. And for that, first we need a bill. What is a bill? A proposal. What is the proposal? The proposal is to split Andhra Pradesh into Andhra Pradesh and Telangana. The proposal was that Hyderabad will be a common capital for not more than 10 years. Less than 10 years, okay. Now, the Chief Minister Jagan Mohan Reddy is saying Vishakhapatnam will be the new capital of Andhra Pradesh. Previously, it used to be Amravati. Hyderabad is the capital of Telangana. But Hyderabad was to be a joint capital for not more than 10 years. This is a bill, this is a proposal. This bill should be first cleared by the cabinet. What is this cabinet? Prime Minister and his top ministers who are part of the cabinet, who are part of this ministry. They should discuss together and they should pass this bill. In a sense, they should approve this bill. Because this bill may be piloted by the Home Ministry. Home Ministry is responsible for these matters. Home Ministry has prepared this bill. Now this bill is sent to the cabinet. Give us your approval. Cabinet discusses this bill. Prime Minister and his ministers discuss this bill. And then this bill should be tabled in Parliament. Because who has the power to pass a bill? Parliament. When both houses of the Parliament pass a bill, then this bill is sent to the President. Once the President signs this bill, bill becomes an act, bill becomes the law of the land, and then Andhra Pradesh will be split, bifurcated into Andhra and Telangana. But there is a consultative process involved under Article 3. What is this consultative process? When this bill, Andhra Pradesh Reorganization Bill, once it was cleared by the Union Cabinet, this bill should be sent to President. President, please give us your approval, because without your approval, we cannot table this bill in the Parliament. That means this bill under Article 3 has a unique provision that this bill, once it is cleared by the Cabinet, Cabinet seeks the permission, approval of the President. Mr. President, please allow us. We want to table this bill in the Parliament because we want to bifurcate Andhra Pradesh into Andhra and Telangana. President, before he or she gives his approval that yes, you can introduce this bill in the Parliament, President has to consult the Legislative Assembly of that state which is going to be affected by this bill. Which state is going to be affected by this bill? Andhra Pradesh. President has to consult the Legislative Assembly of Andhra Pradesh because that state is going to be affected by this bill. So this Andhra Pradesh Reorganization Bill, it was cleared by the Cabinet. The Cabinet sought the approval of the President. Mr. President, can you please do one thing? He said, what? Can you give us the approval? We want to introduce this bill in the Parliament. Yes, but this is a bill under Article 3? Yes. For that, I have to first consult the Andhra Pradesh Legislative Assembly. I said, why? Because Andhra Pradesh Legislative Assembly is going to be affected by this bill. And I'm bound by this process under Article 3. And in a special plane, this Andhra Pradesh Reorganization Bill was sent to the Andhra Pradesh Legislative Assembly. Asking the Andhra Pradesh Legislative Assembly, give us your views. President is asking Andhra Pradesh Legislative Assembly, give us your views. What are your views on the Andhra Pradesh Reorganization Bill? Because the Parliament wants to divide Andhra into two states. Andhra Pradesh Legislative Assembly passed a resolution saying we reject this bill. Andhra Pradesh should be united. It cannot be bifurcated, should not be bifurcated. We will stay together. We will stay united. This view was sent to the President. President basically said, go to hell. Your views are not binding on me. That means even if you say bifurcate or not bifurcate, your views are not binding on me. I'm just consulting you. Maybe you will come up with a good suggestion. Maybe you will come up with your own concerns, which we will take care of. But you can't reject this bill. Your views are not binding on me. When this view was sent to the President, saying we don't agree with the Andhra Pradesh Reorganization Bill, President said, don't worry. President told the Cabinet, you have my approval, table this bill in Parliament. The government said, thank you, sir. This bill was introduced in the Parliament, first in Lok Sabha, then in Rajya Sabha. But this bill can be first introduced in Rajya Sabha as well. So there is no such hard and fast rule. This bill under Article 3, Cabinet clears this, but before it is placed in the Parliament, the Cabinet seeks permission of the President, approval of the President. But President, before giving his approval, sends the matter to the Legislative Assembly of a state which is going to be affected by this bill, asking the views of that state. But these views are not binding on the president. This is just consultation. I'm only consulting you. Maybe you will come up with good solution. Maybe you will come up with good argument, which we will consider, but I'm only consulting you. Your views are not binding on me. When the view was given that please don't bifurcate Andhra Pradesh, President said, had a smirk, smile. President gave the approval to the cabinet. Now you can introduce this bill in the parliament. This bill can be introduced in either Lok Sabha or Rajya Sabha. That means first in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. And in both the houses, this bill requires simple majority. What is simple majority, which we discussed yesterday? Majority of members present and voting, which means more than half of the members present and voting. Lok Sabha passed this bill by simple majority. Rajya Sabha passed this bill by simple majority. The bill was sent to the president. President said, oh, this is my bill. I gave you the permission. I will sign this bill. President signed this bill. Andhra Pradesh Reorganization Bill became Andhra Pradesh Reorganization Act. Andhra Pradesh was bifurcated into Andhra and Telangana. That is power under Article 3 of the Constitution. What is Article 3? A centralizing tendency of Indian federalism. A feature of Indian federalism which makes center very strong, very powerful as against the state. Parliament, which is the central legislature, what it can do, it can pass a law. And through this law, it can bifurcate, trifurcate, merge states, increase the area, decrease the area, alter the boundaries, change the name of a state as well. Even if you want to change the name of a state, even if Madras wants to become Tamil Nadu, even if Orissa wants to become Odisha, even if Uttaranchal wants to become Uttarakhand, the name of the state can be changed only by the parliament. This is not the power available with the states. Clear? Any questions as of now? Okay. Now, we also need to understand how Jammu and Kashmir was bifurcated, how it was converted into two union territories. It raises an important issue relevant for your exam. Let's look at how Jammu and Kashmir was bifurcated. But before we look into that, we need to understand that there was some sort of a special status given to Jammu and Kashmir under Article 370 of the Constitution. But why Article 370 was introduced? What is Article 370? What are the various provisions of Article 370? How Article 370 was changed? That we will discuss separately in Jammu and Kashmir chapter. Here we are not discussing J&K. Here we are discussing how J&K was bifurcated using Article 3. Clear? We are discussing Article 3. We are not discussing Jammu and Kashmir. But just one thing that you need to understand here, so that you can understand Article 3 better, that before this special status of Jammu and Kashmir under Article 370, only Article 1 and Article 370 was applicable to Jammu and Kashmir. Jammu and Kashmir had a special status under Article 370 of the Constitution. Why this special status was given, how this special status was revoked, we will discuss separately in Jammu and Kashmir chapter. But to understand Article 3, you just need to understand one thing, that the special status of J&K under Article 317 meant that only two articles of Indian Constitution are applicable to the state of Jammu and Kashmir. One is Article 1, India, that is Bharat, shall be a union of states. In this phrase, union of states, Jammu and Kashmir is also a part. The name of J&K is mentioned in the first schedule. That is Article 1. And Article 370, which basically means Article 3 of the Constitution is not applicable on Jammu and Kashmir. which means Parliament of India does not have the power to split Jammu and Kashmir, bifurcate Jammu and Kashmir, change the name of Jammu and Kashmir, increase the area, decrease the area, alter the boundaries of Jammu and Kashmir. That is not the power available with the Parliament, because Article 3 is not applicable to Jammu and Kashmir. Simple. But on August 5, 2019, this special status of Jammu and Kashmir was revoked. How it was done, we will discuss separately. But here, just keep in mind, this special status under Article 370 was revoked on August 5, 2019. When it was revoked, that means now J&K does not have a special status. When it does not have a special status, that means Article 3 is now applicable to Jammu and Kashmir. That is one thing that you have to keep in mind. Now, on August 5, 2019, Article 3 is applicable to the state of Jammu and Kashmir. That's number one. Number two, Jammu and Kashmir in 2019 was under President's rule. There was no government in Jammu and Kashmir because previously there was a BJP PDP government. Miss Mehbooba Mufti was the chief minister. BJP withdrew support. The government fell. Then there were series of talks. At one time, the Congress, the PDP, the National Conference, they decided to come together to form the government. The governor said, but there are others, the BJP and Sajad Loans People's Conference, they have also come together to form the government. So what I will do, I will dissolve the Legislative Assembly. And the Legislative Assembly of Jammu and Kashmir was dissolved. So long story short, there was no government in Jammu and Kashmir. Jammu and Kashmir was under President's rule. But when the state is under President's rule, who becomes the legislature of that state? Parliament. Who becomes the executive of that state? The governor. That means if a state is under President's rule, normally the Legislative Assembly of that state will make laws for that state. The Chief Minister and his Council of Ministers, they will govern that state. But when there is no government in that state, it is under President's rule. Who will make law for that state? Parliament. Who will become the government of that state? Governor, who will act on the advice of the President. That means when a state is placed under President's rule, the entire control of that state is given to center. That means now J&K is under President's rule. Who is now the legislature for J&K? Parliament of India. Who is now the executive of that state? Governor. Who is now acting on the advice of the President. Whatever President says, the governor has to do that. This is the political scenario of J&K. And then cabinet. Mr. Modi, Mr. Amit Shah, Mr. Rajnath Singh, Mr. S.J. Shankar, Ms. Smriti Irani, others, they decided to come together. There was a cabinet meeting and a bill was cleared called Jammu and Kashmir Reorganization Bill, just like Andhra Pradesh Reorganization Bill. So the provision was Jammu and Kashmir will be reorganized. Instead of a state, it will be downgraded to that of a union territory, and 2 union territories will be created. Union territory for Jammu and Kashmir, union territory for Ladakh. Union territory of Jammu and Kashmir will have a legislative assembly. Just like Pondicherry, Puducherry has a legislative assembly, although it's a union territory. Just like Delhi has a legislative assembly, although it's a union territory. So the union territory of Jammu and Kashmir will have a legislative assembly, but the union territory of Ladakh will not have a legislative assembly. This was a bill. Jammu and Kashmir Reorganization Bill 2019. Cabinet cleared this bill. This bill was sent to the President. Dear President, please give us your approval. We want to introduce this bill in the Parliament. Said, okay, this is a bill under Article 3. Yes, sir. But under Article 3, I have to follow a consultative process. Yes, what is that? I have to consult the Legislative Assembly of that state which is going to be affected by this bill. Said, yes, but there is no Legislative Assembly in Jammu and Kashmir. Okay. Now, when there is no Legislative Assembly, who acts as the legislature of that state? Said, during President's rule, it's the Parliament. Okay, so what we will do then? This Jammu and Kashmir Reorganization Bill was cleared by the Cabinet, sent to the president. President said, I have to consult Jammu and Kashmir Legislative Assembly, which is not present right now. Instead, I will refer this matter to the parliament. So president referred the matter to the parliament. Their parliament said, yes, sir, you are now acting as the Jammu and Kashmir Legislative Assembly. Said, okay, because the state is under president's rule. Yes, sir. Give us your views. What are your views on Jammu and Kashmir reorganization bill? Parliament said, what are you saying? We agree with this. Said, do I have your view? Said, yes. This view was given. We agree with Jammu and Kashmir reorganization bill. President said, okay, I've got the view. Now, cabinet, please introduce this bill in the parliament. This bill was first introduced in Rajya Sabha. It was passed in Rajya Sabha. Then it was sent to Lok Sabha. It was passed in Lok Sabha. Then it was sent to the president. President said, oh, this is my bill. I referred it to you. He said, yes. President signed this bill. Jammu and Kashmir reorganization bill was passed, signed by the president. It became an act. But then in this act, it was mentioned that it will come into force when the government will decide. And the government, so date was not specifically mentioned. The government said, we will implement this law. We will implement Jammu and Kashmir Reorganization Act on October 31, which is the birth anniversary of Sardar Patel, the Iron Man of India, the man of unity, who was responsible for bringing most of the princely states within the Indian fold, within the Union of India. To celebrate the birth anniversary of Sardar Patel, this law, Jammu and Kashmir Reorganization Act, entered into force on October 31. That's when Jammu and Kashmir was bifurcated into Jammu and Kashmir Union Territory and Ladakh Union Territory. That's how Article 3 was used for J&K. But it raises some key questions. Key questions such as, number one, federalism. Number two, Article 356. What do we mean by federalism here? Listen to me carefully. What is a unitary constitution? All the powers are concentrated with the center. Center can create a state for administrative convenience, can dissolve that state for administrative convenience as well. All the powers are with the center. But in a federal polity, what happens? There is distribution of powers. Clear? Distribution of powers in a sense, some powers given to the center, some powers given to the states. But when we look at these union territories, there we don't see distribution of powers. Union territories are directly controlled by the center. For example, Lakshadweep is directly under the control of the center. For example, Andaman and Nicobar Islands. For example, Chandigarh. For example, Ladakh. All these union territories, Daman and Diu and Dadra and Nagar Haveli, this union territory also is directly under the control of the center. That means union territories do not share federal relationship with the center. There is no distribution of powers. There is no dual government. In fact, the government is of the center. Parliament is also the center. Now, imagine a situation where we have 28 states and 8 union territories. Listen to me carefully. We have 28 states, we have 8 union territories. These states share federal relationship with the center. That means center will have the power to make laws on foreign affairs, currency, banking, insurance. But these states will have the power to make a law on land, law and order, agriculture, gambling, so on and so forth. We will have a chief minister at the state, we'll have the prime minister at the center. There is dual government, there is distribution of powers. But these union territories, who makes laws for these union territories? Parliament. We will exclude Delhi and Puducherry for a while because they have their own legislative assembly as well. But what is their role, we will discuss in union territories. Let's focus on the other union territories. Other union territories which do not have a legislative assembly. Union territories such as Ladakh, union territories such as Daman and Diu and Dadra and Nagar Haveli, Lakshadweep, Andaman and Nicobar Islands, Chandigarh, where there is no legislative assembly. Who makes laws for these union territories? Parliament. Do they have a chief minister? No. which means who is administering that union territory? President. That means entire power for that union territory is vested with the center. Clear? But this federalism, Supreme Court has said, is part of the basic structure of the Constitution. No law passed by the Parliament can violate federalism. No act passed by the Parliament can violate federalism. Federalism is part of the basic structure of Indian Constitution. And there are some critics who say this Jammu and Kashmir Reorganization Act of 2019, it violates federalism. How? Listen to me carefully. First, the state was under president's rule. President's rule by its very nature is temporary. The maximum number of years a president's rule can be imposed in a state is 3. That means by its very nature, president's rule is temporary. Can, during a period of president's rule, which is temporary in character, can permanent changes be made to that state? That's question number 1. That is why Jammu and Kashmir Reorganization Act is challenged before the court. The Supreme Court will have to hear this matter. 1, can during president's rule, where the state is under the control of the center, and this president's rule by its very nature is temporary, can during president's rule, permanent change be made to that state? That's question number 1. And question number 2 on federalism. Federalism in the sense, this dual government, this distribution of powers, which ensures that our constitution is federal. What stops a future government? Today it's the BJP, tomorrow it can be Congress, day after it can be Aam Aadmi Party, then it can be my political party. What stops a future government from using Article 3 and convert Maharashtra into a union territory? That means now we will have 9 union territories. Convert Madhya Pradesh into a union territory, Karnataka into a union territory, Tamil Nadu into a union territory. That means one by one the number of states will go down, one by one the number of union territories will go up. That means we can reach a time where we will have 36 union territories. But these union territories are directly under the control of the center. They are directly under the power of the center. That means Article 1 then would be India, that is Bharat, shall not be a union of states. India, that is Bharat, shall be a union of union territories. Then where is federalism? Because if this power indeed is with the parliament, that it can downgrade an entire state and convert it into a union territory, what stops a government from converting all the 28 states into 28 union territories? Then federalism would be violated. That's the key question that Supreme Court will have to answer when this matter will be heard by the Supreme Court, whether J&K Reorganization Act is constitutional or not. But then there are others who say it is constitutional. Why? Because under Article 3, this power is given with the Parliament. So Parliament has the power. Is there any restriction mentioned in the Article 3 that you cannot convert a state into a union territory? Or you cannot split a state into 2 union territories? There is no such limitation mentioned. So when there is no limitation mentioned, Parliament can do that. And Parliament has used Article 3 genuinely. In the sense, yes, the bill was passed, but it was passed by majority. You can't say that the bill was not passed by majority. It was passed by majority, then sent to the president. President signed this. Even if you say that the views of Jammu and Kashmir Legislative Assembly were not taken, because there was not Jammu and Kashmir Legislative Assembly, because the state was under president's rule. Even if there was a Jammu and Kashmir Legislative Assembly, just like there was Andhra Pradesh Legislative Assembly. Andhra Pradesh Legislative Assembly said, we don't agree with Andhra Pradesh bifurcation. President said, go to hell. Jammu and Kashmir Legislative Assembly, if it was present, it would also have said, we don't agree. president would have said, you also go to hell, we will still bifurcate the state. So there are two sides of the argument. One argument is there is no violation of the constitution because Article 3 gives power to the parliament. Parliament has used its power. Even if there was no legislative assembly, so what? Power is with the parliament during president's rule. Even if there was legislative assembly, even if it would have given its views, so what? These views are not binding. So even if J&K Legislative Assembly would have said, no, we don't agree with this bill, even then we would have gone ahead and bifurcated Jammu and Kashmir. That's argument number one. But then there is a bigger argument concerning federalism and concerning president's rule. During president's rule, which is for a temporary period, can you make permanent changes to a state? That's number one. Number two, what stops a future government from, let's say, Maharashtra? The government is dismissed, president's rule is imposed, then the governor, the parliament, which is acting as the legislature of Maharashtra, will recommend, okay, dissolve or bifurcate or downgrade Maharashtra to a union territory. By that logic, if this power indeed is with the parliament, then it can use Article 3 to convert India into a union of union territories, which would violate federalism, which is part of the basic structure of the Constitution. That is Article 3 of the Constitution. Any questions? Let me know. Is it unconstitutional? But that's not the question for me. That's not something that I have to answer. That's for the Supreme Court to answer. They have to decide whether it is constitutional or not. We don't have to be judgmental here. We just have to understand what has happened, what are the arguments in favor, what are the arguments against. That's it. Okay, so let's take a break. It's 7:50. We'll meet 8:05, and then we will discuss the remaining provisions. See you on the other side of the break. Shall we start? Okay. Now let's look at something else. We have Schedule 1 of the Constitution. And now let's discuss Schedule 4 of the Constitution because that is relevant for this discussion. What is Schedule 1? The names of states and union territories. What is Schedule 4? Representation of states in Rajya Sabha. At the central level, we have a bicameral legislature. We have two houses, Lok Sabha and Rajya Sabha. These Rajya Sabha MPs are elected by the states. So the state legislative assembly members, they vote to elect Rajya Sabha MPs. How many Rajya Sabha MPs do we have from Uttar Pradesh? 31. Where is it mentioned? Schedule 4 of the Constitution. How many Rajya Sabha MPs do we have from Telangana? 7. How many Rajya Sabha MPs do we have from Andhra Pradesh? 11. Where is this mentioned? This is mentioned in Schedule 4 of the Constitution. So Schedule 1 deals with names of the states and union territories. Schedule 4 deals with the representation of states in Rajya Sabha. From a particular state, how many Rajya Sabha MPs will get elected? Those details are mentioned in Schedule 4 of the Constitution. Clear? Schedule 1 and Schedule 4 are both parts of the Constitution. They're part of the Constitution? Yes. Yesterday we discussed special majority. Flavor 2. And I told you flavor 2 of special majority is required for amending the Constitution. And what is flavor 2 of special majority? Majority of not less than 2/3 of the members present and voting, and majority of the total membership of the House. That means more than 2/3 of the members present and voting plus absolute majority. This is flavor 2 of special majority. And this flavor 2 of special majority is used to amend the Constitution. Right or wrong? Right. Now we have Andhra Pradesh Reorganization Bill, or we have Jammu and Kashmir Reorganization Bill. Both these bills are required to do what? To alter the boundaries, to bifurcate the states of Andhra Pradesh and Jammu and Kashmir. Now both these bills are passed by what type of majority? Simple majority. Right or wrong? Right. Now Andhra Pradesh got split into Andhra Pradesh and Telangana. Now this word Telangana should also be mentioned in Schedule 1 of the Constitution. That means we will add Telangana here. Jammu and Kashmir was a state. Now Jammu and Kashmir is a union territory. That means we have to change Schedule 1 as well. Ladakh was not a name mentioned previously. Now we have to add Ladakh as well to Schedule 1 of the Constitution. Clear? But to change Schedule 1, which is part of the Constitution, which means we are amending the Constitution, it should have required special majority. But this bill was passed by simple majority. How can simple majority be used to amend the Constitution? That's question number 1. Question number 2. In Schedule 4, it was mentioned Andhra Pradesh will have 18 MPs. But now when Andhra Pradesh Reorganization Bill was passed, it was signed by the President, we had to change Schedule 4 as well. That means in Schedule 4, we have to mention Andhra Pradesh will have 11 MPs and Telangana will have 7 MPs. But Schedule 4 is part of the Constitution. To make any changes in the Constitution, we need special majority flavor too. But these bills were passed by simple majority. How can a law passed by simple majority make changes to the Constitution, amend the Constitution, Schedule 1 and Schedule 4 of the Constitution? How is that possible? That is possible because of Article 4 of the Constitution. What is Article 4? Laws made by the Parliament under Article 2 and Article 3. Let's say, what is Article 2 of the Constitution? Parliament may by law. What Parliament can do? It can admit into India a state, or it can establish new states. For example, if Jammu and Kashmir Union Territory or Ladakh Union Territory, or for that matter Puducherry Union Territory is to be converted to a state, for that we use Article 2, which means Article 2 says Parliament may by law admit into India. That means Sikkim was admitted into India, or establish new states. We have union territories. If they are to be established as states, we use Article 2. Laws passed by the Parliament under Article 2, laws passed by the Parliament under Article 3, which means reorganization. These laws will make changes to Schedule 1 and Schedule 4 of the Constitution. But these changes are supplemental. These changes are incidental. These changes are consequential matters. And these changes shall not be deemed as amendment to the Constitution. Sir, can you make it simple? Yes, that's my job. For example, you have a target. The target is that today you should study 5 hours. 2 hours to revise polity, 1 hour for newspaper, 2 hours for your optional subject. That's your target. And now you are at your study desk. You have to clock 5 hours of your target. You have to study for 5 hours. But the moment you start reading page number 1, your mind travels to Mussoorie. Lal Bahadur Shastri, National Academy for Administration. What will I do there? What will I wear? How will I talk? President will appoint me. After that, what will I do? Wow, what kind of life would it be? So you are traveling to Mussoorie, to Lal Bahadur Shastri Academy. Now you are planning your entire life. How I should talk, who I should meet, what will I tell my friends? Once I will come back, what will I tell my friends? I will tell them stories about what I did at Lal Bahadur Shastri Academy. And now 5 hours are over. These 5 hours, although you were on table, you were meant to study, but you were not studying. Which means you can't say that these 5 hours I spent studying. Similarly, when a law is passed by the Parliament under Article 2 and Article 3, these laws will make changes to Schedule 1 and Schedule 4. Because unless and until we change Schedule 1, we can't add a new name to it. We can't add a new name to a state or a union territory. We can't add the representation of that state in Rajya Sabha in Schedule 4 of the Constitution. But these changes are incidental. These changes are consequences. Consequences of what? Because you have passed a law under Article 2 and 3. Those changes shall not be deemed as an amendment. So we don't call them amendment. Just like we don't call your spending 5 hours, but you were traveling to Mussoorie, we don't call them working, we don't call them studying, we don't call them practicing. Similarly, a law which makes changes to Schedule 1 and Schedule 4, but because you were passing a law under Article 2 and 3, these changes shall not be deemed as an amendment. When it is not an amendment, that means we don't need special majority. When it is not an amendment, that means we need simple majority to make changes to Schedule 1 and Schedule 4 of the Constitution. But listen to me carefully. I told you about flavor 3 of special majority yesterday. What is that flavor 3 of special majority? Majority of more than two-thirds of the members present and voting, plus absolute majority, plus ratification by more than half of the states as well. Why? If you want to change a federal feature of the constitution, if the parliament wants to amend federal feature of the constitution, it requires flavor 3 of special majority, which means you need ratification by more than half of the states as well. Which means this: if you are saying that we will pass a law to increase the representation of UP in Rajya Sabha from 31 to 51, you need to amend the constitution. But this amendment would be through flavor 3 of special majority, which means you need ratification by more than half of the states as well, because you are affecting federal feature. Why? Because you are giving more representation to one state. This is the question of federalism. That means in isolation, if you are not bifurcating Uttar Pradesh, if you are not reorganizing Uttar Pradesh, tomorrow you can change 31 to 51. If, for example, Uttar Pradesh is also merged with Rajasthan, Madhya Pradesh, Chhattisgarh, if 3 or more states are merged together with UP, yes, the UP's representation in Rajya Sabha will go up from 31 to 51, for example. For that, you don't need amendment to the constitution because you had passed a law under Article 3. But without bifurcating UP, without reorganizing UP, if you are making changes to Schedule 4 of the Constitution, you need ratification by more than half of the states as well. But if you are passing a law under Article 2 or Article 3, where if you are establishing a new state, for example, Ladakh will now be a state, you will have to change Schedule 1, you will have to change Schedule 4 as well, because if Ladakh is now a state, it should have a representation in Rajya Sabha as well. So if you are establishing a new state under Article 2, there will be changes to Schedule 1 and Schedule 4. Otherwise, there is no implication whatsoever. You are just creating a state, but are not mentioning its name in the Schedule 1, not providing representation in Rajya Sabha. So making changes to Schedule 1 and Schedule 4, if the parliament is passing a law under Article 2 and 3, there will be changes to Schedule 1 and Schedule 4, but these changes shall not be deemed as amendment. When it is not amendment, that means you don't need special majority. When it is not special majority requirement, that means by simple majority, you can make these changes. That is Article 4 of the Constitution. So let's recap. Union and its territory, Part 1 of the Constitution, dealing with Articles 1 to Article 4. Clear? Article 1, Clause 1. India, that is Bharat, shall be a union of states. We have two names, India as well as Bharat, reflecting tradition and modernity, shall be a union of states. We are a federal constitution, according to Dr. Ambedkar, but we have used the term union of states and not federation of states because of two reasons. One, India is not the result of an agreement between states, and no state has the right to come out to secede from the Union of India. The names of states and union territories shall be mentioned in first schedule of the Constitution. What is a schedule? An explanatory memorandum of an article. If an article requires more explanation, if we add this explanation in the article itself, it would become bulky, lengthy. Now, this explanation should be added to the end of the Constitution by adding a schedule. Schedule 1 of the Constitution deals with names of the states and union territories. But the territory of India shall comprise up of either we can have states, or we can have union territories, or we can have acquired territories. Acquired territories, for example, Puducherry. Acquired territory, for example, Goa. We acquired it. Then Parliament has the power under Article 2. It can pass a law through which it can admit into union from outside, for example, Sikkim, or it can establish new states. That means existing union territories may be created into states. Parliament may by law admit into India or establish new states, but on such terms and conditions as it thinks fit. And then Article 3 of the Constitution, which gives more power to the center as against the states, which is one of the centralizing tendency of Indian federalism. Under Article 3, Parliament, which is the central legislature, has the power. What it can do? It can increase the area, decrease the area of a state, alter the boundaries of a state, change the name of a state, merge two or more states, split a state, bifurcate a state, trifurcate a state, convert a state into three states. That's the power under Article 3 available with the Parliament. But for that, a consultative process has to be followed. A bill will be cleared by the cabinet, then will be sent to the president. President will refer this bill to the state which is going to be affected by that bill, take the views from that state, although those views are not binding on the president. President will ask the cabinet, introduce this bill in the parliament. Both houses of the parliament will pass the bill by simple majority, and then the states are reorganized. But whenever parliament passes a law under Article 2 or passes a law under Article 3, there will be changes to Schedule 1 and Schedule 4 of the Constitution. But these changes will not be deemed as amendment. We will not call them amendment. Why? Because Article 4 says so. Article 4 says these are not amendments. When these are not amendments, that means we don't need special majority. That means what do we need? Simple majority. Clear? But Schedule 4 of the Constitution, if you want to change, alter, modify, amend Schedule 4 in isolation in the sense without Article 2 or Article 3, if you're not dividing a state, bifurcating a state, or merging a state without using Article 2 and 3, if you want to change Schedule 4, you need ratification by more than half of the states. You need a constitutional amendment. But if the parliament passes a law under Article 2 and 3, there will be changes to Schedule 4. But these changes are incidental. These changes are consequential matters. And these cannot be deemed as amendment to the Constitution. Clear? Okay. Now let's look at the reorganization of our country. In 1947, when India got independence, there were a large set of princely states as well. Princely states which were governed by the princes, which were not part of India as such, as a political entity, but they were governed separately. In 1950, when the Constitution was enacted, the entire territory of India was divided into 4 parts. Part A, Part B, Part C, Part D. Part A had those areas which were previously under the Governor General. So when we were under the British rule, during the colonial times, there used to be an individual known as Governor General who had all the powers. Those areas which were directly under the control of the Governor General, which were under the control, these were big provinces such as Bombay, Madras, Calcutta, Bengal. These were the areas which were under Part A of the Constitution. Part B had those areas which were previously princely states. For example, Mysore, for example, Jammu and Kashmir, for example, Hyderabad. These were princely states. They were kept under Part B of the Constitution, Part B of the reorganization. Then we had Part C, which used to be under Chief Commissioner. During the colonial times, these areas would be under Chief Commissioner. For example, Delhi, Coorg, these were under Chief Commissioners. These were under Part C. And Part D had only one entity, one territory known as Andaman and Nicobar Islands. Now the question before the policy makers, before the government of the day, the independent government was, how do we reorganize the country? Reorganize the country because there were demands for linguistic states. Linguistic states in the sense, a language, Tamil for example, no matter where this language is spoken, all those areas should come under one state. That means one state for one language. Similarly, if there are Kannada speaking population areas, all those areas should be merged to create one entity, one state, specifically for the Kannada speaking population. So the demand was that the entire country should be reorganized on linguistic grounds. One state for Tamilians, one state for Kannadigas, one state for the Malayalis, one state for the Odia speaking population, one state for the Telugu speaking population. So the entire country should be divided into linguistic states. That was the demand. For that, a committee was set up known as Dar Commission. June 1948. Dar Commission was asked, can you please take a look at these demands and tell us how do we reorganize this country? Dar Commission said, don't create states in the name of language. Create states on the basis of administrative convenience. What is administrative convenience? Let me give you a question. For example, we had Bengal. The year was 1905 when Bengal was partitioned. Lord Curzon was basically the ruler of India. What was the need? For which of the following reasons Bengal was partitioned by Lord Curzon in 1905? A. To divide Hindus and Muslims. To displace Calcutta. As the center of India. For administrative convenience. D, all of the above. And let's take a poll. Tell me what is the answer to this question. %30 of the students are right. This is the leaderboard. Amit Kumar, Shruti. Yes, the reason to divide, partition Bengal was to create a rift between Hindus and Muslims. Yes, the reason was that we should displace Calcutta as the center of nationalist movement, because Calcutta was then the capital of India, from where the nationalist feelings got developed. But the reason given by the Britain was that we are partitioning Bengal for administrative convenience, because Bengal is a big province and it becomes difficult to administer and manage such a big province. So just to ensure that we are administering Bengal effectively, conveniently, we are partitioning Bengal. That's the reason. So the answer to this question, which of the following was the reason given by the British to partition Bengal? The answer is administrative convenience. But yes, hidden within this partition of Bengal was British objective to divide Hindus and Muslims, to create a wedge in the society, to create a rift in the society, to displace Calcutta as the center of India's freedom struggle. Similarly, Dar Commission was asked, how do we reorganize this country? Dar Commission said, don't create states in the name of language, because we just witnessed partition. Unfortunately, on the grounds of religion, where India was divided into India and Pakistan. A separate state, Pakistan, was created, and the reason was religion, because Muhammad Ali Jinnah said, two-nation theory. Hindus and Muslims are two separate entities, two separate ideologies. They cannot stay together under one nation. That's why we need a separate state for Muslims called Pakistan. So on the basis of religion, the nation was partitioned. Dar Commission realized that if we start creating states in the name of language, then this language will become the basis for another partition. Then Tamilians will separate from India. Kannadigas will separate from India. Malayalis will separate from India. Odias will separate from India. These are the allegations. We don't know whether that would have happened or not, but these are the allegations. Don't create states in the name of language. Create states on the basis of administrative convenience. Few months later, another commission was set up. December 1948, known as JVP Committee. It is an acronym. J stands for Jawaharlal Nehru, V Sardar Vallabhbhai Patel, P Patabi Sitaramaya. These were the three individuals who were part of this committee. They had to decide, how do we reorganize this country? JVP committee also reiterated that don't create states in the name of language, because that is going to be another reason for partition. Create states on the basis of administrative convenience. Create states of such magnitude so that it becomes easy to govern that state. It should not be too small, it should not be too large. But then something happened. One Gandhian, one follower of Mahatma Gandhi, Polity Sriramalu, he went on fast. What was his demand? His demand was all the Telugu-speaking areas in South India should be merged together to create a state only for the Telugu-speaking population, and that state should be known as Andhra. The government rejected his proposal, rejected his request, rejected his demand, saying we cannot divide states or reorganize this country in the name of language. We have to do that only on the basis of administrative convenience. Mr. Sriramalu went on fast unto death, and ultimately he lost his life. When he lost his life, there was a series of protests in Telugu-speaking areas. Ultimately, government succumbed to the pressure. And in October 1953, the first linguistic state was created in independent India. The first state in independent India was created in the name of language, and that state was Andhra. Although previously Odisha or Orissa was created in the name of language for the Odia-speaking population, but that was prior to independence. That was during colonial times. In the post-independent India, for the first time, a state was created specifically on the grounds of language. The first linguistic state in independent India was Andhra in October 1953. But then the government said, we cannot be taking these decisions just like this. People will start protesting, they will kill themselves, some will go on fast unto death. We can't take this decision like this. We need a technical committee to decide the parameters on the basis of which we can reorganize the country. And for that, in 1953, December 1953, a committee was set up known as States Reorganization Commission, or the first States Reorganization Commission. This was headed by Fazal Ali, H.N. Kunzru, K.M. Panikkar were the other members. They had a job to decide on what grounds should we reorganize this country. And SRC, or States Reorganization Commission, said, yes, language can be the basis of reorganization, but it rejected one language, one state formula. What does that mean? States Reorganization Commission said, yes, language can be the basis of reorganization. Let's create states in the name of language, respecting the sensibilities of the people. But we cannot have one state for one language. What does that mean? If we accept one language, one state, then that would mean almost the entire North India would be one state. Uttar Pradesh, Uttarakhand, Himachal Pradesh, Madhya Pradesh, Bihar, Jharkhand, all these states speak Hindi. So if we give one state to one language, almost the entire North India would be one state because they speak one common language, which is Hindi. That would make this state such a big state that it becomes difficult, impossible to govern, administer that state. So we should be creating states on the basis of administrative convenience. Yes, create states in the name of language, But we can have 3 states speaking the same language. We can have 5 states speaking the same language. One language, one state, this formula is rejected, but yes, language can be the basis of reorganization. Some of the recommendations were accepted, some were not accepted. And ultimately, in 1956, a law was passed known as States Reorganization Act. This States Reorganization Act deleted Part A, Part B, Part C, Part D provisions and instead created 14 states and 6 union territories. That's how States Reorganization Act was passed in 1956. Part A, B, C, D, which was in existence at that time, was done away with. Now we had 14 states and 6 union territories. What are these union territories? Why these union territories were created? Should we continue with these union territories? We will discuss that separately in a separate chapter called Union Territories. But here, after 1956, we saw further reorganization. More and more states got created. For example, in 2000, Chhattisgarh was carved out from Madhya Pradesh. Uttarakhand was carved out from Uttar Pradesh. Jharkhand was carved out from Bihar. Prior to that, we saw more states were created. Andhra Pradesh was bifurcated into Andhra and Telangana. And now at this time, we have 28 states and 8 union territories. But let me ask you, was it good to create states on linguistic grounds? Was it better? Was it good? Was it beneficial to create states in the name of language? Ramachandra Guha, historian who writes in his book India After Gandhi, he says it was a good decision to create states in the name of language. And it has held this country united and together. Why? Because he cites the examples. Examples in our neighborhood. For example, Pakistan. Pakistan was created in the name of language. Pakistan was created in the name of language, but even this was created in the name of religion. But even this religion could not act as a glue to keep the country united. Because there was West Pakistan, there was East Pakistan. In West Pakistan, Urdu, Punjabi was spoken majorly. In East Pakistan, Bengali was spoken majorly. And in East Pakistan emerged a leader, Sheikh Mujibur Rahman. Sheikh Mujibur Rahman almost became the Prime Minister of Pakistan. He almost won the election. But then the members of West Pakistan who were speaking Urdu and Punjabi, they said, how can a Bengali govern us? Ultimately, they did not allow Sheikh Mujibur Rahman to become the Prime Minister. He was arrested as well. So language became the basis of discrimination in Pakistan. Despite the fact that it was created on the basis of religion, even this religion could not bind the two Pakistans together, West and East Pakistan, because language was not respected. And when language was not respected, what happened to Pakistan? It got dismembered. It got split. When East Pakistan launched a movement for its independence, and this East Pakistan became Bangladesh, and India played a stellar role in emerging, in making Bangladesh an independent country. Srimati Gandhi, Indira Gandhi was the Prime Minister at that point in time. Which means in Pakistan, despite the fact that it was created on the grounds of religion, but since language was not respected, Bengali language was not respected, it led to the split of Pakistan. But in India, that didn't happen. We created states in the name of language. Tamil Nadu, Karnataka, Kerala, Andhra Pradesh, Odisha, Bihar, Northeast, they had their own uniqueness. So we created states in the name of language, and despite more than 7 decades have passed, we are still united. No state has come out of the Union of India because we respected language. Let's go south and look at Sri Lanka. Sri Lanka, where the majority population, where the population which was spoken by the majority was the Sinhalese, the Buddhist majority, the Sinhalese speaking majority. But the Tamil minority were discriminated. Tamil language was discriminated against. And this led to the emergence of LTTE, Liberation Tigers of Tamil Eelam, a militant outfit which had the demand that we should create a separate country in the northern and eastern part of Sri Lanka where the language is spoken Tamil. So Tamil was not respected in Sri Lanka, and it led to a civil war in Sri Lanka. This war between the LTTE and the Sri Lankan army, this war ended only in the year 2009. But after horrific human rights violations were committed by the Sri Lankan army. So since language was not respected in Sri Lanka, there was a civil war. Since language was not respected in Pakistan, Pakistan got split. But language was respected in India. States were created in the name of language. That has kept India united, despite our differences. That is why Ramachandra Guha writes that it was a sensible, wise decision on part of the policy makers to create linguistic states in India. And the linguistic states in India has helped India stay united. Clear? But then there are demands. Demands from different sections of the society, from different parts of the country. For example, UP is such a big state that it becomes difficult to manage it. UP is such a big state that it is not convenient to administer it. UP should be divided or bifurcated or even trifurcated into three. Harit Pradesh and Bundelkhand should be carved out as separate states from UP. So we should have Uttar Pradesh, but Harit Pradesh should be carved out of. Bundelkhand should be a separate state from UP. Similarly, Maru Pradesh in Rajasthan should be created. Similarly, Coorg is asking for a union territory status in Karnataka. Similarly, Vidarbh, where we see horrific farmer suicides, distress in the farming sector, Vidarbh is asking for a separate state. Bodoland in Assam is asking for a separate state. Gorkha land in West Bengal is asking for a separate state. Despite the fact that there are these different demands coming from different parts of the country, this is where experts say we need a second States Reorganization Commission. So just like we had a first States Reorganization Commission in 1953, which gave its report in 1955, on the basis of which States Reorganization Act was passed in 1956, we need a similar States Reorganization Commission now because there are these demands coming from different sections of the society. And we also need to understand, is small beautiful? Beautiful in the sense, if United States can have 50 states, can India not have more than 28 states? Can we not create more and more smaller states in India so that they are administered better, so they are administered properly, so that the nation as a whole grows? Should India reorganize the country now in such a manner that we should have more and more smaller states? There are arguments in favor of smaller states. There are arguments against smaller states. Let me know in the comment section, what is your point of view? Should we have more and more smaller states, or should we not have smaller states in India? I'll give you 2 minutes to respond. Now, you can't write in the answer, no, we don't need smaller states. Yes, we need smaller states. You have to justify your answer. Shalu, what's your question, please? Okay. Now let's look at arguments in favor of smaller states. Smaller states are created. Why? Because the argument is it will have a stable polity and it will result in equitable development. For example, if you look at the bigger states, for example, Maharashtra, for example, Rajasthan, for example, Uttar Pradesh, there is no equitable development. In a sense, the entire state is not developed. You will see one particular area developed, but the other areas are lagging behind. Lagging behind when it comes to education, sanitation, health infrastructure, roads, universities, development, the access to power. So if we have more and more smaller states, it will lead to equitable development. That means all the areas of that smaller state will be equally and not partially developed. So why we should have a smaller state? Because it will lead to equitable development of all the areas of that state. Example can be Goa, which is the best performing state in India right now. Take any report, whether it is the Niti Aayog report, whether it is Raghuram Rajan committee report, any report you see, the name comes Goa as the most developed state in India, and Goa is a smaller state. Because smaller state leads to equitable development. And at the same time, it leads to a stable polity. Stable polity in the sense that the governments tend to be stable. They tend to complete their full 5-year term when a state is smaller. Maharashtra, a big state, we saw a shift. Sometimes there is the BJP, sometimes there is the Congress, but they have an alliance. BJP is always in an alliance, Congress is always in an alliance. But when it comes to the smaller states, for example, Himachal Pradesh, for example, Uttarakhand, for example, Goa, we see that there are political parties which win the elections on their own without any need for a smaller support, without any need for other political parties' support. So there is stable polity when it comes to a bigger state, when it comes to a smaller state. So if we need more and more smaller states, because if the states are smaller, it will have stable polity. If the states are smaller, it will have equitable development. Another reason given for smaller state is that less distance between the capital and the other parts of the state. If the state is bigger, Lucknow is in one part of Uttar Pradesh, but then there are other areas of UP which are very far from this capital, which means if you have to meet ministers, if you have to meet secretariat officers, you have to travel long distances to reach the capital, which is a disadvantage. But if the state is smaller, which means the distance between the capital and the other areas of that state will be less, and ultimately it will be helpful for the welfare. If the state is also smaller, a smaller state will also result in making employment opportunities available. There will be focused growth. Employment opportunities in the sense, if the state is smaller, this smaller state will cater to a small population area. Whatever jobs are required, those will be catered to by the existing population, which means we will ensure jobs for these individuals as well. Smaller the state, better we will see the unemployment rate. That is why unemployment rate in smaller states is lesser as compared to a bigger state. But then there are others who say, no, we don't need more smaller states. Why? Because it will be financial burden. Financial burden in the sense, if we create more and more smaller states, that means in all these states we have to set up legislative assembly, we have to set up maybe a high court, we have to set up secretariat, we have to set up offices as well. So it is going to be financial burden that is not going to be helpful considering the economic situation we have right now. That's number one. Number two, if Uttarakhand is an example, Uttarakhand, for example, no matter which report you look at, whether it is Raghuram Rajan Committee report, whether it is Niti Aayog report, the best performing state is Goa, followed by Uttarakhand. That is the argument cited by those who are in favor of smaller states. They say, look at Uttarakhand, which was carved out from Uttar Pradesh. Uttar Pradesh is still lagging behind. But Uttarakhand, which was carved out from Uttar Pradesh, since it's a smaller state, look at how developed it is. But Uttarakhand is developed because of its special category status. What is a special category state status? For example, there are some centrally sponsored schemes. For example, some schemes are launched by the central government. For all the states, the contribution of the central government to implement that scheme is 70, but the states will have to contribute 30% of the funds. So if there is a central sponsored scheme, to implement that scheme, for example, there is an insurance scheme, Ayushman Bharat, any central sponsored scheme, 70% of the funding will be given by the center, 30% will have to be raised by the states. But for special category states, it is in the ratio of 90:10. 90% funds will come from the center. Only 10% will have to be raised by the states. And even this 10%, cheap loans are given by the center. And there are 11 states in India which have a special category status. For example, Himachal Pradesh, Uttarakhand, the Seven Sisters of the Northeast, Sikkim, Jammu and Kashmir. These are the 11 areas which are under special category status, where 90% of the contribution in a central sponsored scheme is given by the center, only 10% is raised by the states. So Uttarakhand has developed, not because it is small, Uttarakhand has developed because it has the special category status. The same special category status is asked by Bihar. The same special category status is asked by Odisha. The same special category status is asked by Andhra Pradesh and Telangana. So if this special category status was not given to Uttarakhand, we may not have seen Uttarakhand developing. And Uttarakhand has developed. But look at the environmental costs that it had to pay. Look at the floods which happened in Uttarakhand a few years ago. And look at the Joshimath sinking that we are seeing now. Because you are developing a hilly area with difficult terrain and you are destroying the ecological balance for the sake of development, you are wreaking havoc in Uttarakhand. So smaller state does not guarantee you development. The development is the function of other factors. For example, special category state status. Similarly, if we have a more and more smaller state, not only is it going to be a financial burden, not only is it not going to ensure development, but at the same time, Jharkhand's example was cited. That Jharkhand is a relatively smaller state which was carved out from Bihar, and Jharkhand is doing better than Bihar. But what is the big contributor? What is the big condition that we see as an argument in favor of smaller state, stable polity. But Jharkhand's polity was not stable. We have had 8 or 9 chief ministers since 2000 when it was created. We have had a chief minister who was an independent member. An independent candidate was made a chief minister because BJP and Congress, they didn't want each other to form the government. They supported an independent. So Jharkhand is not the example which you can cite for a smaller state having stable polity. That means there are some arguments in favor of smaller states. There are some arguments against the smaller states. But then this decision should be taken by Second States Reorganization Commission. Let's organize and have a Second States Reorganization Commission, which will look at the demands coming from different parts of our country and then analyze pros and cons to decide whether we need more smaller states or not, whether we need to further reorganize the country as well. There are clear examples of some advantages when it comes to a smaller state, but there are some disadvantages as well. But for that, we need a Second States Reorganization Commission. That completes our discussion on part 1 of the Constitution, Union and its territory. If you have any questions, please let me know. Is time given to state legislature under Article 3? Yes, time is given. For example, 10 days, 15 days, whatever time is given by the president, within that time, the state legislature has to respond, give its views. But what is that time period is not mentioned in the Constitution. That president decides. Sir, is government setting up a legislative assembly for J&K? That's not for the government to set up. The law has already been passed, which says Jammu and Kashmir will have a legislative assembly. Now, delimitation is also complete. All we need is election commission to organize the election. Once the elections are held, then we will have a legislative assembly in J&K. Does union territories without legislature also has MPs in Rajya Sabha? No. For example, Chandigarh, Lakshadweep, Ladakh, Daman and Diu, Dadra and Nagar Haveli, Andaman and Nicobar, they don't have representation in Rajya Sabha. Because I told you, Rajya Sabha MPs are elected by the state legislative MLAs. So only those states which have a legislative assembly, only those UTs which have a legislative assembly, they have representation in Rajya Sabha. Is J&K becoming state or not? That's the question you have to ask Mr. Modi and Mr. Amit Shah. I cannot answer on their behalf. Although they have promised in the parliament that statehood will be restored soon once the situation stabilizes, but that's a political decision to be taken by the government. What is the difference between admit or establishment of state? You're admitting a state from outside India. You're establishing a state from within. For example, you have union territories right now. You want to give them statehood. So you're establishing a new state within India. Okay. Ladakh Union Territory without legislative assembly. Okay, done. Let's now look at part 2 of the Constitution. Part 2 deals with citizenship. And here we will have to discuss Articles 5 to 11. But Articles 5 to 10 are not of much significance, relevance for your exam. It is Article 11 which becomes important for your exam. But what is citizenship? First, we will discuss what is the idea of citizenship, who are the citizens of India. Then we will look at Indian Citizenship Act of 1955. Who can become the citizen of India? Who cannot become the citizen of India? How the citizenship can be acquired? How the citizenship can be removed? Then we will discuss Citizenship Amendment Act, which was passed in 2019. Then we will look at what is NRC, what is NPR, National Population Register, and what is the difference between a person of Indian origin, the overseas citizen of India, and the non-resident Indian, NRI. All this will be covered in this chapter, citizenship. But first up, what do we mean by citizenship? Citizenship is like a romance between individuals and their state. You owe your allegiance to that state. For example, in India, the entire population of India, all those who are residing in India, can be divided into citizens and aliens. Who are the citizens? These citizens share complete relationship with India, enjoy all civil and political rights. Citizenship chapter, part 2 of the Constitution, under Articles 5 to 11. Articles 5 to 10, I will tell you what they are, but they are not of much significance now for your examination. But Article 11 is important. But what is citizenship? Citizenship is basically a relationship between a group of people and the state, and you owe your allegiance to the state. What does that mean? That means if we look at all the people who are residing in India right now, we can divide them, categorize them into two categories. Some of them are citizens, others are aliens. Who are these aliens? Foreigners. For example, there are foreigners working in India, foreigners residing in India, studying in India, conducting business in India, on tourism related reasons in India, on medical reasons in India. These are what we call aliens. These aliens can further be divided into friendly aliens and enemy aliens. Who are these friendly aliens? Citizens of those countries which share good relationship with India, which share cordial relations with India. For example, US citizens in India, they are friendly aliens. Canadian citizens in India, they are friendly aliens. German citizens in India, they are friendly aliens. Enemy aliens are the citizens of those countries with which India is at war. So tomorrow, if there is a war between India and China, the citizens of China in India, they will become enemy aliens. Clear? So all those who are residing within the territory of India, we can break it down into two categories: citizens, aliens. Who are aliens? Foreigners. Who are these foreigners? Either friendly aliens or enemy aliens. Friendly aliens are the citizens of those countries which share good, cordial relations with India. And enemy aliens are the citizens of those countries with which India is at war. But it is these citizens which share cordial relationship or symbiotic relationship with the center or with the state. How? State confers rights on citizens, and citizens in turn, they have duties towards the state. For example, it's like a legal compact. Only the citizens of India can contest elections. Only the citizens of India can apply for government jobs. Only the citizens of India can apply for various constitutional positions, become judges of the court, become Chief Justice of India, become the Comptroller and the Auditor General. And all fundamental rights are available to the citizens. Aliens also enjoy fundamental rights, except Article 15, 16, 19, 29 and 30. And we will discuss in Fundamental Rights chapter which are these fundamental rights, 15, 16, 19, 29, 30. But briefly here, citizens, they share relationship with the state. It's a symbiotic relationship where the state is conferring rights on the citizens. Citizens in turn have duties towards the state. And these citizens are given all civil and political rights. That means all fundamental rights are available to citizens. Fundamental rights are available to aliens as well. But except these five. These five fundamental rights are not available to citizens. Apart from that, all fundamental rights are available to aliens. But these five fundamental rights are exclusively available to the citizens of India. So these citizens, they share complete relationship with the state. Professor Hannah Arendt, American political scientist, theorist, philosopher, she says, and she gave the beautiful definition of citizenship. She writes, citizenship is the right to have the rights Rights means claims. Can an alien claim government job in India? No. Can an alien claim benefits from the state in the form of subsidies, in the form of scholarships, in the form of pensions, in the form of subsidies for kerosene or LPG? No. But it is only these citizens who can claim these rights from the state. I am your citizen. You have accepted me as your citizen. That means there has to be legal acceptance as well. Tomorrow, Pakistanis cannot claim we are the citizens of India. If they claim, India has to accept their claim that yes, you are the citizens of India. But citizenship is you are claiming you are the citizen and the state should legally accept you as citizen. It is this symbiotic relationship which defines the relationship between the citizens and the state. Sir, it is still not clear. What is citizenship? Citizenship, long story short, according to Professor Hannah Arendt, is the right to have the rights. So only a citizen can claim something from the state. Give me all my fundamental rights. Give me political rights. Give me civil rights. Give me economic rights. Give me employment opportunities. So this right, which is a claim against the state, this is the definition of citizenship. So what is citizenship? Normally, this chapter, citizenship, is not mentioned in the Constitution. If you look at the Constitution of the majority of the countries of the world, this chapter, citizenship, is not mentioned in the Constitution. Because this matter is given to the Parliament. This matter is given to the government of the day. You decide who could be the citizen of your country, who cannot become the citizen of your country. And this cannot remain rigid. It has to change over a period of time. If this chapter citizenship is mentioned in the Constitution, if Constitution defines who can be the citizen, who cannot be the citizen, it becomes very difficult to change it. Because to amend the Constitution requires majority, a special majority, a difficult majority, a tougher majority. That is why Constitution of the majority countries of the world, they don't mention citizenship in their Constitution. Because they leave it to the political class, they leave it to the parliament, they leave it to the legislature. You decide who can be the citizen of your country. But India was unique. Unique in the sense, because in 1947, we witnessed partition. Unfortunately, on the grounds of religion. where there were millions of people who migrated from India to what became Pakistan, and millions of people migrated from what became Pakistan to India. And we had to be absolutely sure who are the citizens of India. That is why Articles 5 to 10, they do not talk about who is going to be the citizen of India. They talk about who is right now the citizen of India. Which means on 26th January 1950, who all are the citizens of India? So that we can identify them, we can give them benefits, we can give them their rights. Article 5, for example, says, whoever is present in India and who has resided in India for 5 years continuously. That means 5 years continuously somebody residing in India is the citizen of India. Article 6 talks about what will happen to those who have migrated from Pakistan to India. Article 7 talks what happens to those who migrated from India to Pakistan, but then they want to come back as well. So Articles 5 to 10 are not relevant for your exam now. Why? Because we are past that stage. These articles spoke of who is the citizen of India at the time of the commencement of the Constitution. That is why I said it is Article 11 which is important for you. Because what Article 11 does, it empowers the Parliament. That what Parliament you can do, you can pass a law, and through this law, you can regulate all matters related to citizenship. That means Constitution has defined only those who are the citizens at the time of the commencement of the Constitution. But after that, the ball is in the court of the Parliament. The ball is with the political class. You decide, you define who can now become the citizen of India. How can they become citizens of India? How can citizenship be revoked as well? That is why Article 11 gives power to the Parliament that you can pass a law, and through this law you can regulate all matters related to citizenship. And that is how in 1955 a law was passed by the Parliament known as the Citizenship Act of 1955. And it is this law which has been amended multiple times. And the last time this law was amended was in the year 2019 when Citizenship Amendment Act was passed. So let's recap. Part 2 of the Constitution deals with citizenship. What is citizenship? Citizenship is like a romance between the individuals and the state. You can say the feeling of citizenship is like when there is an India-Pakistan cricket match and on the last ball, Virat Kohli does something or R. Ashwin does something, hits a double, and then India defeats Pakistan. That feeling, that romantic idea is the feeling of citizenship. A German citizen watching this India-Pakistan cricket match will not feel the same way as you would feel it. So that idea is the idea of citizenship. So citizenship is basically legal acceptance. I'm claiming that I'm the citizen of India, but the state should also accept my claim. Once the state accepts my claim by giving me a citizenship certificate, this citizenship certificate says that now you can claim your rights. And as a citizen, I have all these civil and political rights in India. But when we look at all the people who are residing within India, we can break it down into two broad categories. Either you are citizens or you are aliens. Who are these aliens? It's basically a term, alienus, which means stranger. Aliens are strangers, that means they're not citizens. Aliens can be either friendly aliens, that means citizens of those countries which share good, friendly, cordial relations with India, or enemy aliens, citizens of those countries with which India is at war. And these aliens they do not enjoy all fundamental rights. They do not enjoy Articles 15, 16, 19, 29, and 30. But citizens, they enjoy all civil and political rights. So, in one word, if in one line we have to define what is a citizenship, for that we need to go back to the writings of Professor Hannah Arendt, where she writes that citizenship is the right to have the rights. Once you are a citizen, you have a right to enjoy all the civil and political rights that are available. Only you have the right to apply for government jobs. Only you have the right to vote. Only you have the right to contest elections. This right will not be given to the foreigners. But normally this chapter, citizenship, is left to the political class, is left to the elected representatives, is left to the parliament, because parliament consists of representatives of the people. This parliament has the power to decide who can be the citizen, who cannot be the citizen, how the citizenship can be acquired. But this chapter, citizenship, is mentioned in the constitution because of the sorry partition that took place, unfortunately on the grounds of religion. So when the constitution was enacted, we had to be absolutely sure who are the citizens of India. That is why Articles 5 to 10, they talk about citizenship at the time of the commencement of the constitution. When the constitution was enacted, when the constitution entered into force on 26 January 1950, who are the citizens of India? All those who are present in India and who have resided in India for 5 years continuously, they are the citizens of India on 26 January 1950. Those who have migrated from Pakistan to India before this particular date, they are also the citizens of India. We will discuss that date later. Those who have migrated from India to Pakistan and then they want to come back, if they come back before this particular date, they are the citizens of India. We will discuss that date later. That means who are the citizens of India at the time of the commencement of the constitution? Those are the provisions that Article 5 to 10 deal with. But Articles 5 to 10 or the Constitution of India does not have an elaborate provision, does not have an elaborate list of who can become the citizen, who cannot become the citizen. That power is given to the parliament. Because under Article 11, power is given to the parliament that from now onwards you decide. We, Constitution, has decided who is the citizen at the time of the commencement of the Constitution. After this, Parliament, you pass a law, you decide who can be the citizen of India. And Parliament passed this law in 1955, known as the Citizenship Act, which has been amended multiple times. The last amendment is in 2019. And it is this Citizenship Act which defines, decides, tells us what are the ways by which you can acquire Indian citizenship. What are the ways by which you can lose your citizenship as well. So now we will have to discuss what is this Citizenship Act of 1955. Any questions as of now? Let me know. Is CAA amended with simple majority? Yes, simple majority, because it's an ordinary law. It's not an amendment to the Constitution. And one more thing, we'll do one thing. What are the ways of acquiring citizenship? What are the ways by which you can lose your citizenship? All this we will discuss on Monday. We'll start Monday onwards and complete this chapter, citizenship. Normally on Fridays, we take a look at the previous year's question papers. So whatever we study from Monday to Friday, from these topics, what type of questions have been asked in the prelims exam, what sort of questions have been asked in the mains exam, we discuss all these prelims and mains based questions on Fridays. But today is different. Why? Because we have just started this program. The first class was on Wednesday. So we can't take previous year's question papers today because there are very few questions then we'll have to discuss. We will take previous year's question papers, both prelims as well as mains based questions, next Friday. where we will take all the topics that we will be covering till Friday. Whatever questions have been asked by UPSC from prelims and mains perspective, we will discuss them on Friday. Clear? Right now, whatever questions you have, just let me know. I'll answer your queries. And then on Monday, we will start with Citizenship Act of 1955. There are 5 ways by which you can acquire citizenship: by birth, by descent, by registration, by naturalization, by incorporation of a foreign territory. There are 3 ways by which you can lose your citizenship: by renunciation, by termination, by deprivation. All this we will discuss on Monday. Then we will also look at who is an NRI, who is a PIO, who is an overseas citizen of India. We will look at the Citizenship Amendment Act of 2019. We will look at what is NRC, what is NPR, what is the Assam Accord, what is the cutoff date for citizens or citizenship in India. All that we will discuss on Monday and Tuesday. Right now, if you have any questions, let me know. CAA has been passed, NRC has not been implemented yet. Which chapter to study from Lakshmikant? Union and its territory. Is there an exam tomorrow? Yes, there will be MCQs and a descriptive questions based on what we have covered on Wednesday, Thursday, and today. Pakistani citizens are not alien citizens now, as India is not at war with Pakistan. Right now, the government can decide to specify some citizens of Pakistan in India as enemy aliens, because Pakistan is not a friendly country as well. It's a country which is in conflict with India. If you don't have any doubts, you may leave. We'll meet tomorrow. We will meet Monday, sorry. Tomorrow there is no class. Difference between Union of India and Territory of India. Union of India means the central government, the union government. Territory of India means all the states, union territories which make up the territory of India. What is meaning of republic? The head of the state is elected, is not holding a position because of hereditary. That country is a republic. India is a republic because the head of the state. Who is the head of the state? The President of India. President of India is elected individual. So we say India is a republic. Britain is not a republic. It's a monarchy or a constitutional monarchy, because they have a democracy as well. They have the prime minister as well. But the head of the state is the king, who is not an elected individual. That is why Britain is a constitutional monarchy. Can one person take citizenship of India as well as another country? No, we don't recognize dual citizenship. You can only be the citizen of India, you cannot be the citizen of any other country. Why do we need union territories in India? That's, my dear, I told you, we will discuss separately in union territories chapter. Can we delete the term socialist from preamble? No, we can't. It's part of the basic structure. Sir, is territory under presidential rule? Which territory, my dear? By abrogation of Article 370, any advantage to J&K? We have not discussed Article 370 at all. So once we discuss Article 370, we will discuss your question. 8 union territories. 8 union territories, they are directly under the control of the center, which means the president is the head of all these union territories. But there are 3 union territories which have a legislative assembly or which will have a legislative assembly. For example, Delhi and Puducherry, they have a legislative assembly. Jammu and Kashmir will have a legislative assembly. Apart from these, because these 3 union territories will have their own government as well, apart from these union territories, 5 other union territories, they are directly under the control of the center. Sir, is it possible to implement NRC across the nation? It is possible. It was implemented in Assam. It can be implemented throughout the country as well. Is there any chance that Supreme Court will strike down Jammu and Kashmir Reorganization Bill? Now it is Jammu and Kashmir Reorganization Act because it has been implemented. And your guess is as good as mine. I don't know what Supreme Court will do. Maybe Supreme Court, if at all, it will strike down this law saying that you have to go back to the Jammu and Kashmir Assembly, seek the views of the Assembly. Without their views, whether they are binding or not doesn't matter, but without their views, you cannot use Article 3. But we'll have to wait what the court will have to say on this matter. Is it possible to give Delhi statehood? Is it possible? Yes. Should Delhi be given statehood? There is a debate. Arguments in favor, arguments against. That we will discuss in union territories. Why 15, 16, 19, 29, 30 are not available to foreigners? Because Article 15, for example, deals with non-discrimination on the grounds of religion, race, caste, sex, place of birth. But should we not discriminate foreigners and give more benefit to Indian citizens? Article 16 is related to public employment, government jobs. Do you want foreigners to also apply for civil services examination? Then the competition will become fierce. Then you will lose out. So it is to protect Indians, their interests. These rights are available only to Indians. Why Sonia Gandhi is not contesting an election as she is the citizen of India? Does they have no citizen in India? Is Sonia Gandhi a foreign resident? This question is asked by Femina. Femina, Sonia Gandhi is a Lok Sabha MP. She has consistently contested election. 2019, 2014, 2004, 1999, 1998. She has always contested elections and has won these elections as well. So she has contested elections. She is a member of Lok Sabha. Okay, that is it for today. See you again Monday. We'll start the discussion with the Citizenship Act 1955. Should you have further questions, please get in touch with subject matter experts till 10 o'clock. They will resolve your doubts. I will see you on Monday. Till then, stay safe. Bye-bye.